The Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. I am Justice Sabita Singh. With me is Justice Catherine Hand and Justice Andrew D'Angelo. We will be the panel for today's sitting. At this point, we will call the first case, Commonwealth versus Walter Maines, 23P 921.
Good morning, Your Honors. May it please the Court, my name is William Corman, and it's my pleasure to represent Mr. Walter Maines. From the outset, first of all, I do want to thank the Court. I had some calendaring issues, and I appreciate your patience and tolerance as I tried to sort those through, so thank you very much. What we are asking the Court to do on behalf of Mr. Maines and many other similarly situated defendants is to take the holding from the Supreme Judicial Court in due and extend it out. This case is one we were asking the Court to push a boundary that was left open in the due case. Namely, what do we do with the cases that are pre-2014 where we can't show a direct conflict of interest based upon the passage of time and other remaining issues? The Commonwealth is going to get up here, and I know they're going to start by talking about just how horrific these Facebook postings are of Attorney Doyle. We all know that. The SJC decision in due starts with it, it ends with it. The Commonwealth's briefs start with it and end with it. It is what it is. They're completely indefensible. But the problem is there's a question that remains open. So we know that Attorney Doyle starts posting these offensive, exceptionally offensive Facebook posts at around 2015. And so we then know we have a starting point, if we will, for cases from 2015 on. Attorney Doyle was a bar advocate starting in at least as early as 1998, 1999. Anecdotally, when I was a prosecutor 1,000 years ago in the Roxbury District Court, he was a bar advocate then. That was in 1997. So what do we do with all those cases? And my suggestion is that we build upon the decision that was rendered in due and focus on the concurring opinion of Justice Cipher, where she essentially said, look, we need to, as a matter of fact, the direct quote is, we must be aware of and concerned with the confidence of not just this defendant, meaning Mr. Dew, and not just all black and Muslim clients represented by Attorney Doyle, but rather all black persons and members of the Muslim faith in our community. I'm going to cut that in half, and I agree with that entire sentiment. But if the goal here is to make sure that we protect and entrust the court system with the confidence of all black and Muslim individuals represented by Attorney Doyle, and I actually would suggest it goes beyond that. I think that in due, the individual happened to be black and happened to be Muslim. But we know from the appendix to my brief and all the other briefs that Attorney Doyle's bigotry and hatred extended past blacks, it extended past Muslims, and included the trans community, undocumented individuals, Hispanic individuals. The list goes on and on. There's nobody he didn't like.
Counsel, would you agree that there is nothing in the record specifically to indicate that Attorney Doyle was racist towards Mr. Maine in any way?
Yes. There are two facts that are raised in the government's brief that are indisputable. One, that Mr. Maine's case and many others predate what we know of Mr. Doyle's Facebook posts and others. And the second is, in this particular case with Mr. Maines, there is nothing that we could write in an affidavit that shows that Mr. Doyle, Attorney Doyle, expressed any outward implicit bigotry towards Mr. Maines. But as the government then says in the very next sentence of their brief, it's unlikely that Doyle's racism suddenly sprang from nothing in 2015. That's a quote from their brief, and Counsel, it's right on.
If I could just ask you, you started by saying you want to extend the holding of Dew.
Yes.
And I'm curious in what way. Dew required an actual conflict, not simply a potential conflict or a tenuous conflict. Are you suggesting that something less than an actual conflict?
No, what I'm suggesting is that in Dew, they found there was an actual conflict because of Mr. Doyle's bigotry towards Mr. Dew. And what I'm suggesting is that—
Wasn't it also because of specific conduct with respect to that client? Wasn't that the actual conflict?
In that case, yes. And that's the boundary I'm suggesting that we have to expand. That we can assume, as the government rightly says in their brief, that Doyle's racism didn't spring from nothing in 2015. And therefore, we need to recognize that it came from somewhere. We don't have a point in time, and therefore aren't all, as Justice Cipher suggests, aren't all clients of Mr. Doyle's who were represented by him, who are of a minority, who are minorities, don't we owe them the obligation to accept the fact that there's a conflict of interest there as well?
You're representing Mr. Maines, but your argument is that every client should have their conviction overturned if they fall into what categories?
If they fall into a category of individuals who we know Mr. Doyle posted about on Facebook. And again, that's a tough distinction to draw. What I'll say is this, and this is somewhat anecdotally, but it's also in the supplemental appendix. There's around 6,000, there's exactly 6,759 individuals who Attorney Doyle represented. That's in the affidavit from CPCS itself. We can assume that not all of those defendants fall into some sort of minority classification. It's an assumption, but I think it's an assumption that's accurate. Anecdotally, I've vetted a number of individuals for Doyle review, as we're calling it, and they're individuals who simply don't fit into that category. I wouldn't fit into that category. And I think that we also know that there are individuals who simply defaulted on their first date. There are probation surrenders that nothing happened. There were bail-only cases. Again, again, anecdotally, in the late 1990s in Roxbury, everybody was getting an attorney. The laws hadn't been changed. The rules hadn't been changed. You could get an attorney at an arraignment for a public drinking case. The lawyer would talk to you, and then the case would get dismissed on court costs. It was different than now because of budgetary issues where we parsed out who actually was entitled to a court-appointed counsel and other. So there are a great deal of individuals. I don't think it's quite 6,759, but yes, this case happens to be because of Mr. Maines, but if any of my other cases had made it through the system as quickly as this one, I'd be making the same exact argument.
Can I ask this? I just want to be sure that I understand your answer to Justice Singh's question. Is it your view that due required both the postings and the conduct directed toward Mr. Due to create the actual conflict? That's what I thought I heard you say. No,
I think that just happened to be how it played itself out in that case. What I'm suggesting is that Doyle's racism was enough to be considered an actual conflict of interest. And the Facebook postings themselves, I mean, they're intertwined, obviously. It's the Facebook postings themselves that form the actual conflict of interest. In Due, there's no way around it, it went further. Okay. Mr. Due was able to write an affidavit where he was able to point to specific conduct of Attorney Doyle during that attorney-client relationship. And I think that I think the SJC sort of focuses on that a little bit. Justice Cipher writes in her concurrence, we may not have gone far enough here, but that's not our case because we don't have that case today. I apologize.
About that. Why should we go further than the SJC? Because the SJC certainly has the authority and power, as they did in Farouk and other tough cases, to go further. You're asking us basically to open the door, the gates, to potentially 5,000 defendants. I'm not saying that's necessarily the wrong thing, but why should we go further than the SJC?
I anticipated this question and didn't have a great answer, and Attorney Lynn and I were actually talking about it a few moments ago. I suppose my knee-jerk, somewhat glib answer is that if this court respectfully doesn't believe it has the authority to go further than the SJC, then please make that decision as soon as possible so we can get this case to the SJC. And I mean no disrespect to this court, but if the net result is we don't have the authority to do it, let's do that quickly, because I think that Mr. Maines and a host of other defendants need this issue resolved as soon as possible. Having said that, I do believe that this court does have the ability to interpret cases from the SJC, and while I'm using the phrase go further than, perhaps I'm pushing that. I think that using Justice Cipher's concurrence read in conjunction with the decision in Due, this court does have the ability to say, hey, look, these posts are an actual conflict of interest in and of themselves. And
are the posts an actual conflict because they're publicly accessible? For example, if these are communications that were said privately, and it was somehow discovered later, does that make the difference between having an actual conflict and not?
I think it does, and I'm trying to think back as to to the oral argument that took place in Dew. The issue is, this is not, it would still be abhorrent, don't get me wrong. This was not a fleeting Facebook post in a slew of other things. This was the bulk. And it was a public Facebook page, and I would suggest that every time there was a post, it reinforced this idea that Attorney Doyle was an abhorrent bigot. So,
Well,
it is, I'm sorry.
Let me ask you this. If an attorney has these views, keeps the views to themselves, does a great job as a lawyer for their clients, but at some point later, the private communications between parties is exposed. So you're saying even in that case, this would be considered an actual conflict of interest that would require a overturning of the convictions?
Yes. And the reason is this. All lawyers, we're cogs in the machine, if you will. And I think that we owe a duty to our clients, and we do owe a duty to the law and to the bar, if you will, to act in a professional manner. And the fact that Attorney Doyle was a criminal defense attorney shouldn't matter, because I would suggest that if a prosecutor had these posts and they were found out several years later, this would be a different conversation. I would suggest respectfully to the bench, if a judge had these posts and they were found out many years later, we probably wouldn't even be having this conversation. But
So what is the difference between an actual conflict and a potential conflict in the view of how you think these cases should come out?
Because I think that if there's a potential conflict of interest, perhaps there needs to be prejudice that's shown, and an actual conflict of interest does not require prejudice. And I'm suggesting that
But what does a potential conflict of interest look like? It sounds like there's in the view that you're painting, that if someone privately holds these views, even if we can't show that it affects their professional work, that we should consider that an actual conflict. So that leaves me to wonder, what is a potential conflict in that setting? Is there no such thing as a potential conflict?
Hypothetically, I suppose that if there was one fleeting post in a trove of Facebook postings, one could say, maybe, just maybe, this one post or an obtuse post. These were not. These are not obtuse posts. These are blatantly racist posts. These are not fleeting. These are ongoing and going and going. From posting from courthouses. This isn't even something he's doing on a Sunday afternoon while he's sitting around watching TV. There are posts from courthouses where he's checking in and making statements.
What about if a criminal defense lawyer doesn't like a lot of his clients because he represents murderers, rapists, etc.? Hold on.
I just can't hear, Your Honor, that's all. I just couldn't hear the court.
A criminal defense lawyer doesn't like the clients he's representing. And he posts, I hate representing these criminals, they're murderers, they're rapists, etc. But his result, or her result, is fantastic. He or she puts all those biases aside and does a great job. Isn't that an actual conflict based on what you're saying?
No.
What's the difference?
I
am not, obviously, none of us are saying that Attorney Doyle's conduct was good. It was reprehensible. But what if he was able to put aside all of these horrendous personal views and just represent his clients to the best of his ability? Because that's what criminal defense lawyers do.
But we know he didn't do that.
How?
Because we know that from the Anthony Dew case.
Do we know that from the Maines case?
I don't think it matters. I think once we start down that path, then we have to take into account all of his cases and look at them under the same
Let's say we
microscope.
don't agree with you that an actual conflict has been established in this case, right? Then we're looking at a showing of prejudice. What showing of prejudice has been made?
I don't know that there is one. I don't know that there is one. And that's the problem. And that's the problem. Because, again, if we look at 6,700 cases from 15, 25 years ago, there are going to be cases where again, anecdotally, I've spoken to dozens of people who don't even remember Attorney Doyle as their lawyer. So we are not going to be able to show on a case.
In this case, again, let's limit ourselves to in this case, Mr. Maines had an opportunity to do an affidavit, explain, the relationship. The judge actually, in this case, made a finding. Mm-hmm. The judge made a finding that this seemed to be a good result, and there seemed to be work put into it. We have those findings on the record.
Absolutely.
Right. So the showing of prejudice could have been made in some way in this case, but it wasn't.
If it was there, yes. And that's why I'm respectfully suggesting that these Facebook posts that we all keep talking about how terrible they are, they create the conflict of interest. And if we don't consider that they do, as Justice Cipher said, what are we saying to the minority community who is relying upon court-appointed counsel because they can't afford their own? They don't have the choice to vet out other lawyers. If we're saying that this conduct doesn't create a conflict of interest, if you are an African-American man and your lawyer is posting on the internet, I'd give them the Jimmy Hoffa treatment. I'm representing thugs. I told them to bring their toothbrush because I didn't like their attitude, and I didn't like their attitude because of their race. What are we doing? Thank you.
Good morning, Your Honors. Excuse me. May it please the Court, Paul Lynn for the Commonwealth. The most important thing here is that Attorney Doyle did not show any signs of prejudice in this case, and not only in this case. Even after these horrible Facebook posts came to light, in no case that I have handled has there ever been anybody, a judge, a probation officer, a prosecutor, a defense attorney, a clerk, who ever suspected that Doyle was racist based on what he did in the courtroom. And we cannot grant a new trial to Mr. Maines based on speculation about how Attorney Doyle felt in 2011, a good 2.5 years before he posted any bigoted Facebook posts.
Attorney Lynn, without getting into the issue of the dates at this point, doesn't the outcome of due suggest that what everybody thought Attorney Doyle was or wasn't thinking, it doesn't matter? That to the extent that the failure of people to recognize that this problem was going on doesn't mean it wasn't going on.
Correct, Your Honor, but I think the distinction is it was going on at the time that Attorney Doyle was representing Mr. Dew. And I think the court has a point, although we argued against it in Doyle, that when you look at these Facebook posts, they are just combined, of course, in Dew with the fact that Attorney Doyle made disparaging statements about the defendant's Muslim garb, that they simply could not allow that kind of misconduct without granting a new trial. And I think that it's important to realize that once these Facebook posts became public, you do have a problem because you now have an attorney who is saying these awful things. And as Justice Cipher said, you have to look at the entire community and what the entire Massachusetts community, mostly Suffolk County and its adjoining counties, but what the entire community that Doyle represented believes in the criminal justice system. And I think it's fair for the court to say, for the court to have said in Dew, that if you have a person who is making these terrible statements while he is representing his client, and he also privately makes anti-Muslim statements to the client himself, you can't let that conviction stand. But here you have two fundamental differences. And the first is you have no public posts, nothing, there's no evidence that Doyle posted anything offensive before, about anyone before January of 2014, and specifically to black people in January of, I believe January of 2015. So here you have no manifestations of racism in the representation. You have no posts. You don't have either of those factors, and I think you need those factors to have an actual conflict of interest.
Once the issue of racism, once the fact of racism arises, though, whose burden is it to demonstrate when that racism began? Because it seems unlikely, to me anyway, that it stems from, that it arises suddenly and without any precursor with the first post.
Correct. I mean, the Commonwealth concedes that in its brief. It's unlikely that on, I think it was January 20th, but we'll use that date for, on January 19th he was fine, and suddenly he woke up on January 20th a screaming racist. We admit that. But there's still a difference between someone who is making public statements that demonstrate his racism and treating his client in a racist manner. And as you have already argued, just someone who harbors these feelings but is able, as his record shows, to put those out of his mind and represent his client zealously. And the judge here found specifically that he had represented his client in this case, Mr. Maines, quite zealously. He had committed 2 violent crimes. He had been identified by both his victims, and Doyle still got a sentence of time served followed by probation.
Wouldn't the judge in dues in the trial court have said the same thing based on the record before him or her? There was a good result in dues. There was no showing that Doyle had done anything wrong. The SJC overlooked that.
Correct, absolutely, because of the factors I've already pointed out, because there was these public statements that the court simply could not overlook without undermining the faith of the community in the impartiality of the justice system.
Let me piggyback to something Judge Singh said to opposing counsel. Let's say these weren't public. Let's say the lawyer had made these racial epithets and crude comments to his friends. What's the difference? He's still harboring, as the judges said in SJC, he's still motivated by virulent anti-Muslim and racist views because he's telling all his friends about it. Why does the posting on Facebook make it any different?
Well, I think the court looked at that in both Dew and the Ellis case, on which both sides relied in that case, about the difference between making an offensive comment and making it to court officials in Ellis, making it in public posts in Dew, that otherwise we do assume and can assume if there is no public displays that this is just like an attorney feeling unclean, to use Doyle's words, because he represented an accused rapist. He represented a vicious murderer. It's not enough to create an actual conflict of interest.
Here's the sentence from Dew that strikes me. Although we cannot know with certainty whether Doyle's actions or inactions during the course of the representation were motivated by anything other than defendant's best interest, on the record before us, we cannot credibly assume that Doyle's representation was not affected by his racist views. How is that any different than this case? We have no idea whether Doyle did a good job or not a good job, but we have to believe his racist views existed when he was representing Mr. Maines, don't we?
I think that's, again, the answer to Justice Singh's question about the burden. It's the defendant's burden. That is clear. That's Commonwealth versus Comita. That's the presumption, once a defendant in this case pleads guilty or is convicted by a jury, is that he got a fair trial. It is then the defendant's burden to show that he could not have gotten a fair trial. And you do have a significant period of time here, 2.5 years at least, possibly 3.5. People do change. It's unlikely that he, again, went from being totally fair-minded to being racist in a short period of time, but it is certainly possible that his bigotry increased over time. And that was the standard that both the courts in Ellis and Dew used, was, is it, I'm having trouble with the exact language here, but is it so pervasive, a level of prejudice that is inconsistent with rational decision-making? And we simply have no evidence that he was as prejudiced in 2011 as he was in 2014.
Counsel, would you say it's accurate that the vast majority of the posts had to do with Muslims, and much less so with blacks, people from maybe other communities.
I agree, but that doesn't really make his anti-black posts less culpable. They were also somewhat more political, the Colin Kaepernick post being a perfect example. I would not want to hang the Commonwealth's hat on that, but it certainly is true that he was he had particular malice toward Muslims.
I was just, I was thinking about the, his explanation had to do with his response to 9/11. So there was an event.
Yes.
So it's not necessarily true that certain biases are sort of there all the time. There was an event that in his explanation as to what caused him to have this kind of hostility.
I agree entirely, Your Honor.
And so, are there other, I'm thinking of the conflict of interest question and the difference between an actual conflict and a potential conflict. Are there other, besides this framework of racism, are there other examples where we look at conflict of interest and the dividing line between an actual and potential? Isn't there always, when we have an actual conflict, it's got to somehow rear its head in the representation?
I agree. I think that's true. I think that's why the court relied on, in part, on the manifestations of racism that Doyle showed in the Dew case, his calling, pardon my language, calling the defendant's kufi that shit and telling him not to wear that shit in the courtroom. So I think you can look at that and say where you just have strong feelings, which, as we've argued throughout this process, don't necessarily create a conflict of interest. That we, as the court said in Ellis, we expect attorneys to represent people they don't like. In fact, we consider the attorneys who take the cases of people that they don't like or people that society doesn't like as particularly exemplary and heroic in some cases. So I think you have to be careful of how far you take this, because otherwise you will end up with people getting their convictions reversed just because their attorney, there's some evidence somewhere that their attorney didn't like them.
Is there any framework that you could envision that is a less, egregious isn't the right word, but other than saying anyone represented by Attorney Doyle that's of color or minority should be granted a motion for new trial? Is there anything less than that that you could envision as a framework?
Yes, I absolutely do, and I think this case presents a good example. You say anybody who is certainly Muslim and arguably any other group, although they could address that issue specifically as the cases come up as to whether Doyle's comments amount to virulent racism against any particular group, like, for example, trans people, where I believe he posted only 1 or 2 posts, and they were, again, highly political. But I think it is perfectly acceptable to take the Dew case and interpret it to mean that there's an actual conflict of interest only where Doyle was making the posts while he was representing the defendant and his racism was manifest in some way in his representation. I think you could clearly say that anything short of that is not grounds for automatic reversal. Are there any further questions?
Thank you.
The Commonwealth will otherwise rest in its brief. Thank you very much.
Thank you. Thank you, counsel. Second case on the list is Commonwealth versus Rousan Hemingway, 23P 980.
Good morning. May it please the court. ADA David McGowan for the Commonwealth. With me this morning is ADA Alyssa Tochka. We are asking this court this morning to reverse the decision of the motion judge below, allowing a motion to suppress a firearm based on two legal errors. First, a misidentification of the moment of seizure, and the finding that there was insufficient specific and articulable facts justifying the Terry stop. The second issue, the court, if it were to decide in the Commonwealth's favor, makes the first one irrelevant, but I think the first one is also important because it's clear erroneous nature under the law. So the first moment of seizure, the motion judge found that Officer Smurs seized the defendant when he began pursuit of an already running Hemingway. So that finding is at page 55 of the appendix. That is erroneous because Mr. Hemingway was already running, and as the SJC in this court has affirmed over and over again, following someone with sufficient speed to keep them in sight without more, some plus factor, either physical or verbal, is simply not a seizure.
What do we do with the judge's finding with respect to the officer's testimony that no command was given? The footnote that says, well, this is unlikely, and goes on. What did the judge actually find there?
That no command was given, Your Honor. That's the finding. He credits Officer Smurs, I believe, in two places, expressly in one, and that is the statement. And I think that's reasonable based on further evidence, particularly the video evidence in this case, at the distance that is depicted. That's exhibit number 8 that I believe was transmitted to this court under a joint motion of the parties. In that motion, particularly clips 16, 17, and 18, show the distance between Mr. Hemingway running and Officer Smurs, that a command would have to be quite loud to be conveyed and heard by Mr. Hemingway. So I think the motion judge correctly credited that no verbal command was given, and I don't think that footnote redlines that finding. Where no command was given and there was no altering of Mr. Hemingway's path of flight in some physical nature, there was no seizure. The motion
What
judge...
about the number of people who are in pursuit?
The motion judge seems to give great weight to that, and there's no evidence from the record at all, even in the affidavit in support of the motion, that Mr. Hemingway was aware or in fact could have been aware of the robust police response. Now, there was a shooting. Officer Smurs was one of the first ones there. The video evidence shows that, particularly clip number 18. They're sometimes a hard puzzle to put together, but the clips are meant to be chronological in nature and during the path of flight. On clip 18, when Hemingway enters the Bromley Heath housing development with Officer Smurs with his flashlight following behind, he's inside, 1 Mississippi, 2 Mississippi, however many seconds later, Officer Smurs is inside continuing pursuit. That is when the cavalry, the additional 8 to 9 officers, come around from the parking lot and then they follow in. Hemingway is inside the building prior to those officers being potentially visible. They're totally obstructed. The video, you can see them coming. They do not turn the corner until both Mr. Hemingway and Officer Smurs are well within inside the building. Further, if you go on to a clip, I believe it's 21, in a somewhat Looney Tunes type reenactment, most of those officers go the wrong way. They go down into the basement, and one officer continues to follow Officer Smurs. So the weight that the motion judge put on the sheer police response can't be attributed to as a manifestation of pursuit plus something else to create a moment of seizure well in advance.
Can't we infer, just based on the number, and I recall the clips, I don't disagree entirely with your characterization of what they depict, but can't we infer that at least the sound of 9 people running on concrete behind the original officer is going to be apparent to someone who's already in flight?
That is possible. I don't think that's a necessary and arguably not a reasonable inference in this case where Mr. Hemingway is in full sprint to a doorway. I'm not sure if there was a lot of officers visible potentially on his periphery that he would notice them. I would then have to confront the fact that there are a lot of officers on his periphery. So I don't think footfalls. Addition, there's a lot of people here. Officer Smurs described, and as was credited, 20 to 40 people at the moment where he's tending to the gunshot victim. There's a lot. So footsteps in and of themselves in a dense public housing complex I don't think it cuts one way or the other in this instance. But what is helpful to the Commonwealth is that they could not be seen as officers one way or the other from where Mr. Hemingway was, and there's no risk of that because he's well in the building at that time.
Counsel, can I ask you a hypothetical? I'm going to change the facts ever so slightly. A police officer goes up to somebody, as he or she has a right to do, and says, "Hey, what are you up to?" And the defendant takes off running. And that person who asked that question is an officer, has a badge around his neck, and takes off running after the defendant. Is that a seizure?
No, not
Wouldn't a
under,
reasonable person in that defendant's position believe that if he stops, he's going to be seized?
under the case law, no. I think that there needs to be pursuit plus something. If it was, hey, I need to talk to you right now, I think that tweaks the hypo against me. As the court has postulated in this hypothetical, the case law seems to be quite clear, including recent cases, that wouldn't amount to the pursuit plus something else. And a lot of
Could the plus be causing the person to quicken their pace?
I'm not sure that's a fair reading of the case law because the case law of states in Franklin and reaffirms multiple times that maintaining your speed with which to keep eyesight on whoever you or whomever you want to look at is okay. You need to have something more, that being a command or a physical manifestation of that. That's why I think the motion judge wasn't wrong in following the thread of the sheer size of a police response, but that would have had to have been conveyed or observed by the defendant for it to have the legal effect in this case. So if there were, say, in Judge Angel's hypothetical, 15 officers based on that one prompting all pursuing, that might be enough. It might be.
Yes,
but
I was going to ask that. Why does that change it based on your theory? Again, we're still looking at a reasonable person. He knows the person following him is an officer or officers. I guess I'm flummoxed as to why you think a reasonable person wouldn't believe if he stops, the police are going to grab him. That's why they're running after him.
Well, I see Your Honor's point. There's a common sense understanding of this, and that's why I think some of the cases go into such fact-specific parsing for exactly the concern Your Honor has. And while I wouldn't have been shocked if at some point the case read just pursuit alone is enough, it hasn't, and it hasn't over and over and over again. And for I think the obvious tangents, the logical extension of that is it would really undercut police's ability to look into and to do things to keep the community safe. To hold that following, or if someone quickens their pace, to not also quicken your pace, would undercut very good police work. That's why the parsing and the analysis of the moment of seizure has to be pursuit plus, and this is going back decades and affirmed recently, including in the 16L letter I submitted from a decision this past, now last month on the 11th. And that is reiterated, and in that case, in the Russell case, albeit unpublished, the suspects they were pursuing had fled from police. So there was presumably sirens and flashing lights and a show of authority to effectuate a stop, and that had dissipated by the time they interacted with Mr. Russell and his companion. And that is not this case on these facts. The officer did not say anything, did not do anything to prompt the headlong flight, and the factors that prompted Officer Smers to give attention to Mr. Hemingway are incredibly important. If the arrival of the officers, going back to the moment of seizure briefly, I'd like to turn to reasonable suspicion in a moment, but the moment of seizure when all the officers of the footfalls were determined to be a seizure, if that was where the court wants to articulate it on these facts, the firearm had already been tossed. Prior to clip number 15, government suggests is an arm movement, and that's where the gun was found, that is where it is tossed. Where the cavalry arrives, that the motion judge gives weight to, is after the abandonment and tossing of this firearm. And I think that's why the reasonable suspicion analysis, I believe, controls and can remove from this court the thorny issue of determining the moment of seizure. But if it is at that point, and I disagree that that's when, it's after the abandonment of this firearm.
If we're going to follow through with the principle that a person has a right not to answer the questions of police officers and walk or run away, how does the fresh pursuit of the officer get into that analysis? Seems like a hollow principle to have, to say you can walk away from a police officer or run away from a police officer, but if the police officer chases you, that's not a seizure.
I think there are fact patterns as you flesh out that hypothetical that could ring quite hollow, but that's why each case is addressed on specific and articulable facts. In this case, it's not just pursuit, it's pursuit following a shot spotter activation, a police response in a minute, maybe less.
That goes to reasonable suspicion, doesn't it? Let's take out, again, I'm going back to what you started with, take out the reasonable suspicion. The police show up, showing their police officers, and a person runs away. Has a right to do that, right?
Of course.
So the police can chase after that person, but it's not a seizure. Again, I'm trying to figure out how does that work into the analysis.
In that narrow, well, ideally and thankfully, all of the cases, more facts develop in time or precede. On that facts, more would have to follow. How long is the pursuit? How is the individual jogging? Is the officer sprinting? It becomes very important what is said by the officer, if anything, as in this case. So I do see concern, as the court does, in that hypothetical on those bare facts, but I've never seen a hypothetical.
Isn't that what we have here?
No, absolutely not.
Based on when the chase starts, or I won't call it the chase, based on when the defendant takes off. At that point, he's just there, and he takes off as soon as he sees the police, presumably.
No, and the motion judge found there is more too. And I think there were more than the motion judge identified, but on the Commonwealth Appendix, page 56, the motion judge says, in the matter before the court, Smurs possessed the following information at the time of the stop. General knowledge of BHHD, Bromley Heath Housing Development, as a scene of prior gun arrests, 2 separate and very recent shot spotter activations in the area of Bromley Heath, Jones leaving the Bromley Heath with 3 guns, Cersei suffering from a gunshot wound inside Bromley Heath, defendant walking away from a potential crime scene, defendant's shoulder movements as he left the area, enormously important here, the defendant's decision to run, apparent position of Hemingway's arms as he began to run. So prior to any following or moving surveillance or hot pursuit, there are all of those factors. And I would argue that there are 2 more the judge didn't identify but also didn't discredit, and that's the nature of the scene. It's mentioned elsewhere in the motion judge's findings and opinion. 20 to 40 people are around, a lot behaving unruly. And Officer Smurs' personal experience of 9 years on the job, over 100 firearms arrests, including arrests that he couldn't give the exact amount of in the Bromley Heath development. So when Mr. Hemingway turns the corner, and after the movements, and Officer Smurs is following, and then he takes off, that is a factor here that can be considered in the reasonable suspicion analysis. His flight.
At the time the chase begins, there was reasonable suspicion?
Absolutely.
All
Absolutely.
what the judge found.
The reasonable suspicion begins as soon as Officer Smurs Officer Smurs observes Hemingway make movements with his shoulders and arms. At that point, the Commonwealth's position is that there's reasonable suspicion, but there's no seizure. Then after Mr. Hemingway ducks around a corner, Officer Smurs looks around the corner, and Mr. Hemingway's taking off. That is a factor that bolsters the already existence of reasonable suspicion in the Commonwealth's mind.
Counsel, the judge, so this confused me a little bit on the judge's findings, because the judge does credit those initial movements, but it seems later on discredits that he's armed. Do you read that?
I don't. I see I know exactly where the court's getting that. I don't view that as discrediting. What I view, how the motion judge approached it, similar to, I think, using Evelyn as a potential guideline, as going through each factor and assigning weight. And that's how I read the opinion, and frustratingly, each important consideration seems to take on less and less weight as the evaluation goes, and unsurprisingly, the analysis is that there wasn't enough. I think the case is cautioned against that exact approach. That is a hyper-technical reading. All of those factors need to be taken into consideration together, not one at a time and dispelling or not. It is the motion judge's right to assign weight. That is how you reach a legal conclusion on any of these motions. in this case, it was erroneous based on how it was done on the facts in conjunction with the case law and the precedent that we're operating under. That's why in Evelyn and Franklin and DePisa, all the cases evolve towards you consider all these you consider all these factors and reach a conclusion. I see that my time is up. Are there any further questions?
Yes.
Thank you.
May it please the court, and I'd like to answer the question Judge Hand asked right from the beginning. The motion judge did not find credible the police officer's testimony that no verbal command was given. He specifically said, I find that unlikely. So just want to clarify the record on that. At no point did he find that a verbal command had been given. And it should be clear with respect to the first point of pursuit. Your honors have the benefit of the tape, but the motion judge also has the benefit of assessing the credibility of police officer Smers. It's a heavy burden to overturn a judge's findings when he has heard the credibility of the witnesses. In fact, it's been called extremely rare that an appellate tribunal would do so. Here, you have a chase that begins with one police officer, Officer Smers, and then portions of which are depicted in the video. At one point, the judge accurately says there are as many as 8 and then 9 police officers joining in the chase. You also can see dome lights. There's also a finding that all of the police officers were basically white, carrying flashlights as they chased him. You also have testimony that everybody else in the area of Bromley Heath was black. You have a police car that's readily identifiable from which Smers exited as a police vehicle. The counsel, as opposing counsel said, the case law is pretty clear that a chase alone is not a seizure. So what is the plus factor here that turned it into a seizure besides the running? Well, chase alone, if it's over a certain distance and if it results in redirecting the path of a suspect, can be a seizure. And I would point to the concurrence in Commonwealth versus Franklin, where former Chief Justice Marshall said that chase may constitute a seizure under Article 14 of the Massachusetts Declaration of Rights if being chased by police officers at close quarters at a fast-running pace and for some distance, a reasonable person would conclude that the object of the chase is capture. That is, that the police purpose is to restrain his liberty, not merely to be afforded the opportunity to talk to him. That consequently, if he stopped running, he would not be free to leave, and that in effecting the capture, the police will resort to physical force if necessary. That's what distinguishes this case from the ones he's citing. In the most recent case by the appeals court, there was not even a finding by the motion judge and no basis to conclude that it was a high-speed chase or any chase at all. There was no basis to conclude that the police activity had prompted the defendant to flee. Here you have Judge Belizos very carefully, in his opinion, finding that this was a high-speed chase almost right from the beginning. And even Officer Smers admits that he was winded and that he was running so fast as was the defendant. So in this case, what's different is you have a defendant being chased by 1 and then 9 police officers around Bromley Heath, and you'll see the video at one point being chased into the project. You see 2 officers following him. You see 7 officers or 3 or 4 officers going down a basement. They're literally chasing him around the Bromley Heath like this. If that's not anybody being chased like that would think that he's not free to leave. It stands logic on its head to think that anybody in that position would not reasonably believe that he was free to leave. So on that point, we contend that Judge Belizos clearly made a reasonable finding. It certainly is not clearly erroneous such that this court should disturb it. And on the reasonable suspicion part, here you have the judge carefully weighing, again, all of the evidence. He basically finds that this defendant was doing nothing different than any other black person in the area of the crime scene. He was not menacing a police officer. He was not belligerent. He was not doing anything out of the ordinary except walking away from the crime scene. That was it. There was no bulge observed. There was nothing discarded that an officer observed. All he did was walk away just like others were walking away. As the trial judge, the motion judge said, he doesn't know what drew Smers' attention to him, but he was no different than anyone else. And the judge rightly relied on the Warren case insofar as the fact that he ran when he looked over his shoulder and saw the police officer narrowing the gap. Under Warren, that's something that black people have to deal with every day. And that's something that there's an alternative explanation for. And in this case, if you're walking away from all of these dome lights, it's not enough to just stop somebody because they're black and then to be chased. Warren explains that should be given very limited weight. Just like the quote, high crime scene of the Bromley Heath should be given very limited, if any, weight. As the judge held, there are thousands of people in the Bromley Heath who were doing nothing criminal. And
that's Smers' observation of what Smers believed to be the defendant's hiding something, moving something in front of his body and putting it away. Why does that not contribute to the calculus?
So with respect to that, the judge basically made 4 findings, again, which we suggest should be upheld unless clearly erroneous. He basically said that Smers could not see anything from the front. He only could see him from the back. The judge said that there was nothing to suggest a weapon from a shoulder movement like this. And when the officer said, I had training for one day in a ATF briefing, the officer was unable to link any of that training as to how that would mean that this person had a weapon. And critically, again, this is a fact finding which shouldn't be disturbed unless clearly erroneous. The video didn't bear out what the officer said. When you look at the video and when the judge looked at the video, there was nothing unusual. He was running with his hands like this, not with his hands like
That was
in
a separate
front of
event.
him.
There was the shoulder movement and then the running with something in front or not, as the case may be.
But there was nothing about the shoulder movement that the officer linked to the training to show that that would in some way be indicative of a weapon. And when questioned about the training, the officer candidly admitted that they never showed what it would look like in the training if a defendant or suspect didn't have a weapon in front of him. So the officer gave, the motion judge gave some credit, but ultimately found that there was no link shown by Officer Smers to a weapon. And given that, again, unlike these other cases where there is either something shown to be discarded or some noise of a gun falling to the ground, these are the types of cases the Commonwealth is citing, there was no such indication in this case of that at all. In fact, Your Honors are no doubt aware, and there was a colloquy with the motion judge, nobody ever saw a weapon discarded by the suspect. That doesn't exist in this record because nobody saw it. They found the weapon in a garden bed, in front of the project, but they never saw this defendant discard it at all. So this record is bereft of any evidence of this defendant's criminality whatsoever. The only issue raised was one the judge carefully considered about the shoulder movement, and he found 4 reasons to discredit this officer's testimony on that point, not the least of which was the contradiction with the videotape.
Counsel, can the running itself be considered a factor in reasonable suspicion?
Under Warren, limited. Under Warren, it's the SJC has held, if you're running, you might have a reason to do so if you're black, or if you're a member of a protected class. And here, that's exactly what you have. You have somebody running only after a police officer begins to chase him and begins to narrow that gap. So under Warren, it's of very limited anything. And remember, here's the critical thing in this case, lest we forget the big picture. No description of a suspect. No description of who did the shooting or when they did it. You don't even know here whether the suspect was white, the shooting suspect was black, the shooting suspect, how he was or she was dressed. You have no description of a suspect. And right up until the moment that they actually tackle him on the other side of Bromley Heath, every officer was forced to concede, we have no idea who fired these shots that were alerted by the device. We don't know if he was black, we don't know if he was tall, we don't know if he was short, we didn't see him throw anything. I mean, if there were ever a case that should be a suppression of evidence, this is that case. And that's why this judge, in his lengthy opinion, considering all of the evidence and making all of the findings, suppressed the evidence here.
Counsel, do you think it's reasonable under the circumstances presented? Would it be reasonable police conduct that we would expect to have somebody running away from a shooting incident and for the police to not follow that person?
And they did with this defendant was not running away from the shooting incident. He was walking away from the scene. That was dispositive, I think, to the judge, was that it was only when Officer Smers pulled up with the other 3 officers, got out of his vehicle, and then began following him and closing that gap over a lengthy distance.
But doesn't the judge make a specific finding of following an already running person?
Well, there are cases that say there can be a pursuit if you're running after an already running suspect. And that begins with Thibault, and there are other cases that say the same thing. But here he was just walking away from whatever had happened where the shooting was believed to have taken place. He was not running, he was not doing anything unusual. He was just walking away from the scene.
But upon the police arrival, he takes off.
At some point he does, because Officer Smers begins to follow him and begins to close the gap.
I guess that's where I'm missing, where in the findings that comes through. You're making it seem, and I'm not disputing it, but you're making it seem as if the officer is walking towards the defendant and then the defendant runs away. My understanding of the findings was that upon the police arrival, basically getting out of the cruiser, he takes off and starts running at that point.
No.
Where in the findings does it say that he was walking and the officer was walking after him?
It's in the findings. The judge basically says, and in fact, the officer admits, it's when he's being followed and when the gap is beginning to be closed that the defendant looks over his shoulder and then begins to run.
So if there are no other questions, I would rest on my briefs.
Thank you. The next case is Commonwealth versus Christopher Hunt, 23P 530.
Good morning. May it please the court, Peter Brewer from Great Barrington representing Christopher Hunt. The issue at hand, as your honors know, is the issue of primarily focusing on the other bad act, if you will, that was admitted into evidence. This case involves an assault which occurred, an alleged assault which occurred in August in the basement of the complainant's home, her parents' home, where she and the defendant had been watching TV. They had been drinking during the day, and the defendant, as indicated in the transcript and generally the testimony of the complainant, he was obviously in a reprehensible way, eventually was engaging in what he hoped would be amorous activity. And it's described by the victim or the complainant. If you were to pay your attention to page 6 of my brief, she describes it repeatedly. He wanted to kiss her. He knocked them both over trying to kiss her. He was trying to kiss her. It was very sloppy. But he never made a fist or punched her. Now, the Commonwealth sought, and it was contested by motions in limine, to admit an activity or an action that occurred 2 months later, which occurred at a concert that the individuals went to in Portland, Maine. And at that concert, the defendant had been drinking. He was turned off, I believe, by the venue, by the facility there where he had been drinking, where the concert took place. And after that, almost inexplicably, inexplicably from what we know, obviously, he engaged in a violent attack on the victim, things that would almost amount to mayhem, we might say, if we wanted to step it up to consider how extreme it was. What's alleged is that he bit her face, he pulled her hair, and he punched her. And again, this seemed to be a reaction to the fact that he was no longer allowed to drink and was told to pull out his motor vehicle or given directions by the people at the venue. I would suggest, from a starting point in analyzing this situation, is the cases on other bad acts appear to me to indicate that there has to be some uniqueness, some similarity. And I would
what was the purpose given by the Commonwealth as to why this other bad act was being put forward?
They suggested, I believe primarily, Your Honor, that it was a hostile relationship between the parties. Is that,
yes,
in other
yes.
words, what was the permissible reason?
Yes.
Your Honor is asking. Thank you. I think they focused really on the hostile relationship between the parties. So my starting point in considering the admissibility is the difference between the two. On Your Honor's point, there is a substantial testimony that indicates that these parties, first of all, after the incident that happened in August in the basement, the father intercedes, he splits up the parties. The father testified as well, says, you know, that's it for tonight, you go downstairs, and daughter, the complainant, goes to her room. Next morning they get up, they do have some conversations. I believe the father makes breakfast for them, and then the complainant drives him home. They later on testified, distinguishing, if you will, some of the cases where they talk about a delay in reporting, because I believe Commonwealth also used that notion to say, well, she didn't report it for 2 months, and that's, I'd have to think about the name of the case on that, might be Myers, but the point is that this justifies the delay, the hostility in the relationship. She had some fear. However, the testimony of the complainant was such that we never considered reporting it. And the parties go on, on, and in fact, the complainant indicates that things were okay, things were going on okay.
Doesn't the Portland incident explain why she then did report the incident 2 months later? Because another incident occurred?
Oh, absolutely, Your Honor, and I'll get to that. Thank you for asking. The reason so again, we have this situation in Portland where there's remarkably violent attack on this individual, as alleged, pulling her hair, biting her face, and so she obviously goes to the police in Portland. Portland sort of kicks her back to Massachusetts, the local department says make a report there and also do an evaluation. You should have an evaluation for a domestic violence situation. And so there, she does report the incident in Massachusetts, in the basement of the house, which results in the charges, as we're well aware. But if that answers your question, it does remind me of another issue of concern here, and that is one of my principal concerns here is I believe that the motion court, the trial court, really didn't properly balance and recite on the record the balancing, because they have that discussion, Your Honor, in the argument on the motions, and it seems as though the Commonwealth is saying, and this is page 9, I'd referenced you to page, I think it's 9 of my brief, which hopefully accurately reflects the record. They have this conversation, and the Commonwealth, the ADA, says, well, it'll be very limited, Your Honor. It'll go to the fact that she went to the police she went to the police station in Newbury, and there she described the main incident to obtain a restraining order. And then the trial judge says there, the court stated, obviously, if this starts to go beyond that realm, I'll put a stop to it, allowing the Commonwealth's motion. But nevertheless, I think there, the trial court, the motion court recognized, there's a difference between saying I went to Newbury, another incident occurred, and therefore I got a restraining order. And that other incident that occurred was in Maine. And I think that conversation, as I recite on page 10, already suggests that the trial court had some concerns. And so what is the...
Doesn't that also suggest that the judge knew that it was a balancing test and he was exercising his discretion about whether it was probative versus prejudicial? He kind of comes out and says, yeah, I realize this is bad. It's prejudicial, changing his words, but I think it's really relevant. So I'm not quite sure how your argument about he wasn't balancing it. It seems like that conversation shows that he was balancing it appropriately.
Thank you, Your Honor, for pointing that out, because I view it somewhat differently than you in this respect. I think he recognized how serious it was, certainly how serious biting her face, pulling her hair, and punching her was. And that's why he said, if it goes beyond that, I'll put a stop to it. Now, I think in a more thorough balancing, which the court directs to take place, a sort of almost a 1, 2, 3 step, which has been done in other cases, the court might have reached a point where it says, a little more specifically, if you will, Your Honor. Okay, yeah, you can say you went to the Newbury police. Another incident, told them another incident had occurred in Maine. And so now I'm coming back here to tell you about this. Help me get a restraining order. I think in a proper balancing, the judge would have articulated, gone a little further than I feel he did here, because I think his balancing here was inadequate, gone a little further. And when he says if it goes beyond that realm, well, I think the realm the judge is talking about is you can say you were up in Portland, there was an incident, but you can't say biting your face, pulling your hair, and that sort of thing. That's where I see the distinction.
But how did the incident come out? Was it anything that anybody could have done? I mean, wasn't it simply the witness's response to a question, and that couldn't really have been controlled? Perhaps something could have been done after the fact about it. So I'm wondering if your complaint really isn't the lack of a balancing test, but it's that nobody buttoned down exactly how it would play out. And whose responsibility was that?
Well, thank you, Your Honor. I don't think those 2 points that Your Honor makes can really be separated. If I may, this court, and Commonwealth appropriately puts out in in her brief where she kind of challenges me on this idea. Maybe I looked too hard at that word undo, sort of coming up with definitions. I might have been reaching too far for the ring on that. But nevertheless, I really stress this notion of balancing. And this court has said 2 or 3 times, well, they didn't really articulate the balancing, but it's not fatal. Well, they didn't really articulate the balancing, but it's not fatal here. Well, how many times does this court need to say that to the trial court? Because here I think, and this is why I say, Your Honor, I think they're intertwined. I don't think you can separate them and say, well, this line, maybe it could have been corrected by an instruction by the judge because it went too far. I think a proper balancing test here, somebody would eventually said, okay, and I shouldn't say somebody because we obviously assign the errors to the bench. My error that I find in the bench here is not having properly balanced. And when I say somebody would have said, perhaps, an appropriate balancing would have refined it down to, yes, there was an incident in Portland, and therefore I'm getting a restraining order, but not there. I was punched in the face, my face was bitten, and my hair was pulled. I think, Your Honor, that stuff, that description of the Portland incident, I would almost say it hijacked the jury's mind.
How do we make that decision when the judge gives what I think was, based on the record, an appropriate limiting instruction? He specifically tells them what that evidence is being utilized for. How do we ignore that?
Your Honor, I understand that the limiting instruction is there. I think it's, if I may, sometimes these limiting instructions can be somewhat vanilla, if you will, particularly where you have what I would suggest is kind of a shocking incident versus well, again, the incident in the basement in August was inappropriately, nonetheless, of an amorous nature where she repeatedly says it was kissing. This other one was really kind of shocking activity. And I would suggest as...
Whoa, wait a second.
Perhaps I didn't answer properly. Thank you, Your Honor.
It was only kissing because she was able to get away from him on 2 separate occasions. He grabs her, she's able to struggle and get away. He grabs her again, she struggles to get away, and then she flees out of the basement. I don't think we want to leave it that it was just a kissing incident.
Your Honor, forgive me, all 3 of you, if I implied that somehow that, he did continue to endeavor to get her to return. And I didn't want to, certainly we're not suggesting that his efforts at physical relationship, which were completely and appropriately rebuffed, as anyone has a right to do. I don't want to suggest that that was somehow okay. I will say throughout her description of it, she's sort of repeating that were his efforts. And I also note, Your Honor, that at one point, probably in cross-examination, the complainant in the basement discussing it says, he never punched me or made a fist. So it doesn't justify the first incident, Your Honor. And certainly grabbing her, trying to get her remain while not appropriate, I would suggest without question that it's different than what happened in Portland. And, the Commonwealth makes a point that, well, they're the same in the sense, I think later on in Commonwealth's brief, they make the point that they are the same because this is what he does. When he doesn't get his way, trying to have a physical relationship, he gets violent. When he doesn't have his way getting more drinks at the venue in Portland, he gets violent. To me, that shows how difficult for a jury to make this distinction, because I think that's a propensity argument the Commonwealth makes. This is what he does if he doesn't get his way. If he'd gotten his way up in Maine and he could have another drink, well, they're saying, that characteristic of his would not have come out. So I think that's a propensity argument, and I think it goes to there are circumstances, recognizing they're different. I don't know if it's Creighton, in which case it is, but somewhere the court does say this is one of those rare instances where we think even an instruction isn't enough. And there was a case, let's see.
So, counsel, you think this case falls into that category because the subsequent incident so overwhelmed what was actually being prosecuted?
That's my point, Your Honor, and I use the term hijacked because I really think it does. I mean, the allegations of what happened in Maine are just terrible. and you hear a female witness testifying to that, you got to be a little shocked, biting her face, pulling her hair. And I think there's a distinction. And so, okay, so, I think the other case that we're thinking of where the court says an instruction isn't enough, maybe that's the one where they brought up 7 or 8 instances, and it got to the point where all they were trying was the instances, and that was a case where the court said, okay, an instruction isn't enough. But here I would suggest that while there weren't multiple instances, they were talking about an instance that was so shocking to the jury that, again, I think it just hijacked their senses, potentially. And so there are instances, there are categories where the instruction is not enough. And that's my thought there. And I would say there are such cases as that. Your Honor, if there's no more questions, I think the balancing was a key point of mine. I don't think it was adequately done here. Had it been, I think that distinction between the 2 incidents would have better fleshed out. Thank you.
Thank you.
Good morning. May it please the Court. I'm Catherine Semmel for the Commonwealth. In this case, we say that the judge appropriately exercised his discretion in balancing probative value and prejudice of this subsequent bad act evidence. There is nothing in the judge's finding that suggests that he used an incorrect standard. In fact, as I believe Justice D'Angelo pointed out, his comments throughout made it clear that he was balancing the probative value versus the prejudice. He brought up the fact that he was going to give a limiting instruction, sua sponte, and discuss the fact that the testimony should be limited so as not to overwhelm the case. I think.
How was it limited?
It was limited in.
Brief. I get that.
I think that's how it was limited. Was that it was brief. There was no reference to, for instance, I know in the proffer, the Commonwealth mentioned that actual hair was found on the ground. There was really just this happened, and then it was reported to the police.
But did the details really need to come out?
I think they did.
If the purpose was to explain the delay.
I mean, the details I think were important, and to just saying, as I think my brother suggested, that another incident occurred is not telling the jury anything very helpful about what happened, that something violent happened, that something aggressive happened. And I don't think.
But isn't that the improper inference?
It is both. I mean, it is part of the balancing. Yes, it can be used by the jury improperly, which is why you have instructions, but it's also what explains the delay. It's also what shows the parallels between the 2 incidents.
Parallels seems to me to run into issues. Are you saying that the 2 incidences are enough to make a pattern of conduct, or are you saying that it's propensity because they're similar?
I'm saying that it makes a pattern of conduct, and
the judge didn't instruct on that, and the Commonwealth didn't argue that. So, right? I don't believe the judge said pattern of conduct. He talked about hostile relationship and delay. So that's what I think.
That could be true. That could be true. I'm not sure, Your Honor. I think the prosecutor did mention that it was similar, that he didn't get his way, and this happened. But I think that the major focus was, in fact, on the hostile relationship, as you say, on the fact that she didn't come forward right away, and how it did come, that she did come forward and tell what had happened 2 months after the fact, and that was important. And I think the bottom line, to jump way to the end, the bottom line is that jurors acquitted the defendant of a very serious kidnapping charge in this case, which suggests that jurors were not swayed improperly by evidence that came in, did not use it for propensity purposes, but in fact weighed the evidence that came in properly as they were instructed to by the judge, and as they're required to do. The fact that I think they were close in time is of relevance in this case. They were only 2 months apart, really there is a long history in its Commonwealth of allowing in prior or subsequent acts of violence in domestic relationships like this, to explain for jurors, to show, and I think it was really particularly necessary given the interaction in this case, and given the fact that it was theoretically amorous, as the defense has said, and to explain and what the defendant's intent was, which is a part of the assault and battery, when he grabbed her and jumped on her and pushed her down and held her, and in those instances, the subsequent bad act is very relevant to his intent in that.
Isn't the intent just general intent on assault and battery?
It's intent.
I'm not sure what you mean by intent.
It's intentional versus an accidental or negligent conduct. It's intentional touching, intentional and offensive touching.
Was there any claim of accidental touching?
No, but the suggestion is certainly that this was not an aggressive action on his part. I think is the suggestion that it was not meant to be harmful to her in this case. So in these instances, I think the subsequent bad act was very much probative, that the judge carefully and correctly weighed it. And I would note that with regard to what was specifically testified to by the victim, there was no objection brought by the defense at that time that this is not what we said, that this was too far, that this is not what we agreed to. There was no additional objection beyond the objection way back during the motion to eliminate. And I don't think that this was unexpected. I think this is what was understood that she was going to testify to, just the bare bones of what happened and at that subsequent offense, and that it was not inappropriate, and that the judge properly exercised his discretion in this case.
In the judge's limiting instruction, he doesn't make any comment about that it can be used to show why the victim delayed disclosure. All he mentions, at least in the first limiting instruction, is the hostile relationship between the parties and the state of mind of the defendant. What do we do with that when that was argued in the motion in limine, and it seemed like the judge said that that was partly why he was going to let it in, but he doesn't give any limiting instruction to the jury? What do we do with that?
Well, I think that, that the judge, in effect, he didn't, if he didn't give the instruction to the jury, that's telling the jury a permissible use of the evidence, correct? That would be telling them you can use it to explain why she didn't come forward. If he didn't tell them that, then it feels like it is the Commonwealth's loss. He did tell the jury what he was supposed to tell the jury on the defendant's behalf, which is you can't use this for propensity. He's not charged with those offenses. You can't use it to find that he committed these offenses. If he didn't give a proper permissible use of it, that was the Commonwealth's loss, in my view. There are no further questions. The rest of my brief.
Thank you.
Thank you very much.
At this point, the court is going to take a break.
Court all rise, please.
You too. You too.
This court is now in session. Please be seated.
We'll now hear the case of John Whittier versus Jeff Anderson, 23P 1108.
Good morning, Your Honor. May it please the court, Tad Hewer on behalf of the plaintiffs. I want to make 3 key points this morning about why the land court committed clear legal and factual error in denying standing to these 10 plaintiffs. Its first clear error was concluding that ORA met its burden of rebutting with evidence, not just argument, this presumption of standing enjoyed by the 5 statutory abutters. We have 5 statutory abutters and 5 non-statutory abutters. And this error was particularly egregious as to the traffic claims with respect to the Tioga Pony Farm. That's the direct abutter that pleaded specific, unique challenges associated with maneuvering their 40-foot horse trailers in and out of their commercial driveway.
Can I ask this question, and I may be opening a can of worms by asking it right out of the gate, but if the LOS assessments that took into account congestion at stopped points along a 1-mile road concluded that there would be a de minimis impact, if any, then why is the issue of the backing a horse trailer in or out of another intersection on that roadway different?
There's a difference between intersections and driveways. So the LOS study is as to intersections, and there are 3 intersections. There's one on each end of the road, and there's a T-junction. That's the 3rd one. So those are the intersections. It then, not in the initial study, looked at, but the supplemental study looked at driveways. And it looked at residential driveways. Expressly, it's called a residential driveway study. And it said that 3 hypothetical residential driveways representing 3 different places on this road concluded that the LOS wouldn't change.
Does the pony farm not include a residence?
It's not.
That's what I'm asking. It has no residence associated with it. It's only a
It's a pony
commercial
farm.
enterprise.
That's all it is. It's a commercial pony farm. The owners live elsewhere.
Apologies for interrupting. Go ahead.
So there's a commercial driveway, and all they did was look at residential driveways, and they looked at hypothetical residential driveways. There are only 10 houses on this street. There's no difficulty in picking, everyone knows where they live, picking where those 3 driveways are and doing a study for those driveways if they thought that mattered. But instead they said they did a representative one of residential driveways. So none of ORA's pleadings focused on the commercial driveways. And as a matter of law, because these were statutory abutters entitled to a rebuttable presumption, the standing inquiry should have stopped there. ORA didn't respond with the evidence it needed to rebut that presumption. It responded with other evidence, more convenient evidence for ORA, but not the evidence needed to rebut these standings. And instead, the land court shifted that burden back to the plaintiffs. That was the first error. The second clear error was concluding that ORA rebutted claims about safety by submitting evidence about a lack of traffic jams. And then it compounded that error by holding that no plaintiff had sufficiently pleaded individualized safety harms. Now, the land court acknowledged in its decision that traffic and safety are distinct and expressly protected interests under the bylaw. But then it inexplicably decided to, quote, address them together. Now, plaintiffs provided sworn affidavits in the record about existing personal safety hazards that they experienced using the road, and they made reasonable inferences, which is allowed under Quigley, that's Chief Justice Piper's decision from the land court from years ago, that increased traffic will increase those harms. The land court and ORA ignored safety and denied standing on this non sequitur of there being no traffic jams at intersections. Again,
can I ask you a
yes.
question about the affidavits and standing?
I think we're only here on standing, Your Honor,
Right.
so.
Well, the affidavits, at least in part, seem to conflict with one another. Now, I have seen other cases where a judge actually holds a trial on the issue of standing only. In this case, that didn't happen. How does a judge make findings of credibility based on affidavits alone?
So it's slightly distinct between the statutory and the non-statutory abutters. As to how the court does it, for the statutory abutters, and those are the key ones in our opinion, the court has to take what they've pleaded as true. That's standard notice pleading. And they've pleaded it properly, and nobody disputes that they've pleaded these things. So the court essentially has said, we accept as true what the statutory abutters have pleaded as their injuries. The burden in zoning then shifts under Standerwick to the defendants, and the defendants have to respond to those things, and that's the evidentiary discussion. I think the court here erred because it looked at evidence that didn't rebut the claims that were being pleaded. It looked at other evidence that seemed to be more convenient instead of the evidence about the things that the plaintiffs were saying were actually going to injure them. And I think as to, again, to the statutory abutters, because of exactly that point, as to no pleading as to safety, just pleading about traffic jams, the statutory inquiry ends there for standing. The rebuttable presumption was not rebutted. And as to those plaintiffs who live on Waldingfield Road, who are not statutory abutters, there's some quirks here because the properties are so large in this area that some people abut and some people don't abut, even though they seem to be right next to the house. But as to those who live on Waldingfield Road, who are not statutory abutters, they can't escape or avoid these safety harms because there's nowhere for them to go. Their harms are quintessentially different than those of the rest of the community. I would say, put plainly, if traffic and safety are both distinct, expressly protected interests in the bylaw, if standing exists where a plaintiff pleads that increased traffic will delay him by a short amount of time for getting out of his driveway, standing must exist when he pleads a heightened risk to his own personal safety from that very same increased traffic when he's walking his dog along his property's frontage. The two are no different from one another. Both are protected in the bylaw, but only traffic was addressed by the court and by ORA. Safety was left alone. For the rebuttable presumption plaintiffs, certainly, and for the other plaintiffs also, that is fatal. I think the third clear error was the conclusion that diminution in property value cannot provide an independent basis for standing. The land court ignored the controlling precedent of this court in Epstein and its own decisions in Bergman, which was written by Justice Spicer, the same judge who wrote this decision, and Bostek by Judge Foster, all of which, and this is important, post-date Standerwick. Standerwick is 2006, Epstein is 2010, Bostek is 2014, Bergman, Justice Spicer's other opinion, is 2017. Each of them provides that diminution is an independent basis for standing where, as here in Ipswich, the bylaw affirmatively protects conservation of property value. And crucially, and I really want to underscore this, this protection also has a legislative basis. And that comes from the text of the Zoning Enabling Act. Now, the Zoning Enabling Act is Chapter 808 of the Acts of 1975. That's what establishes what gets codified as Chapter 40A in the general laws. In Section 2A of the Zoning Enabling Act, that 1975 Act, says that the legislature expressly states that the objectives for which municipal zoning might be established include, quote, to conserve the value of land and buildings. So Ipswich, when it adopted its zoning in 1977, pursuant to the Act, decided to adopt that legislatively authorized objective. And its choice to protect land values in its zoning law must be respected. Now, the plaintiffs have suggested that the purpose section of the bylaw is not relevant here because it doesn't reflect the GEPD specific section. I would say that that can't possibly be true, and we know it's not true because of the land court's own decision here. In this decision, the land court held that the purpose section established traffic as a protected interest. That's Record Appendix 2, page 151. Traffic and safety are both protected interests under the bylaw because its express purpose includes, quote, lessening congestion in the streets, and, quote, to secure safety. And we know they do it again because on page 157 of that appendix, it says, where, as here, the bylaw's express purpose includes protecting against overcrowding, congestion, and undue concentration of population, density is a protected interest. So to assert that the purpose section lacks legal weight only when it references property value, but not when it references traffic or safety or density, is the definition of arbitrary and capricious.
If we agree with you, is the remedy a remand?
A remedy is a remand. A remand goes back to the land court. But I think the appropriate issue here is that there will be a remand for certain issues, maybe for certain plaintiffs, right? There are different plaintiffs who are differently situated. I think that's another important point, that the land court treated all 10 of these plaintiffs as the same, interchangeable. They're not. As we know, standing is individual. Only one individual needs to have standing for this case to proceed. And the land court said all 10 of these are the same, whether they are the pony farm that has commercial interests, whether they're people who walk on the road, whether they're people who live on the road, whether they're people who live down the street, they're all the same. That can't possibly be true.
I'm sorry to interrupt you. Could I ask two questions? One of them is, can you give me what your strongest case is on the, for the argument that one who lives on the road has a special interest in the activities of walking, biking, whatever it may be, because they live on the road and aren't coming from the outside?
So I think the key here is, this is Quigley and some of the other land court cases, Scott versus Knox, which is a noise case, right? Those are individuals who were in the general vicinity. Scott v. Knox is another case by Justice Spicer, so he's well aware. They're in the vicinity, but they are not necessarily direct abutters. They are entitled to standing. The question, I think this more specific question, is this safety of the individual, right? And I think our position is that these individuals cannot get away from their location unless they move, of course. So it's not like they're coming to the nuisance. The nuisance is coming to them. And in this situation, the reason it's related to zoning is, as I said, if you're going to go walk your dog and you're going to walk out of your driveway and walk along the perimeter of your lot, that's affecting your property, how you use your property. And the fact that you have an increase in traffic, which you know, and they've pleaded, no one in this dispute, has created safety issues in the past, Quigley says it's entirely reasonable for you to say that those safety interests in the past, due to traffic, will likely increase if you have a demonstrable, and everyone here agrees there will be a 30.6% increase in traffic if this project is built, increase in traffic.
So let me ask this other question, which, and I realize this is hair splitting and I may be off track on it, but I'll ask anyway, which is, at what point when there's evidence introduced, I understand that your clients alleged there would be a safety impact that they perceive based on, and they're asking for, I take it, an inference, a logical inference that increased traffic is increased safety risk. Where there's evidence that's introduced that says the road does not need, in its current state, amelioration for safety purposes because there have been no motor vehicle-related accidents that involve people, pedestrians, or equine.
Right.
Then where is that not speculative? How come that's not speculative on your client's end versus a reasonable inference?
Right. So every zoning case with standing is going to have some level of prospectivity because, by definition, the project that people are concerned about hasn't yet been built. So the standard isn't that it's speculative and because it's happening in the future. It says there's a reasonable inference. And I think here the reasonable inference comes, and again, I'll go back to the Quigley case because it's a very similar case. It's individuals who are concerned about traffic, they're concerned about safety. There's going to be an expansion of a large commercial project, in that case a hospital, in their immediate vicinity. And Justice Piper says that's appropriate. You can make a reasonable inference that if you've observed traffic and safety is already being problematic, that the addition of a large commercial use will make that problem worse. And I think, I hate to say it's common sense, but where these individuals have properly pleaded that and no one has said that that is an issue, the only issue we have here is the traffic study, which basically says the road is safe for cars. I will say with respect, my clients don't really care if it's safe for cars. They care whether it's safe for them. Getting a car more quickly at a speed to their location because it can zip through an intersection at the corners is hardly what we're looking at for the purpose of an agreement for standing. Quite frankly, if they said the fact that there's congestion at an intersection gives me standing here, makes much less sense than there's going to be an increased amount of traffic on an already dangerous road. And the road we know has...
Is it already dangerous? Based on the evidence that's presented here, your clients have, as I recall, and with respect to their understanding of their own experience on their road, have indicated that they are careful about traffic coming and going, that traffic has had some impact on spooked horses from time to time and caused people to step off the roadway, all of which I understand. But where is that proof of a dangerous roadway?
It's dangerous because it's dangerous to them. I mean, the court didn't take a view, but you can see from it, and it's pleaded, and I don't think anyone disputes, there are no sidewalks. There is no place for snow push. There are hairpins. The road was laid out over 300 years ago. So it's designed to be a narrow, 2-lane at most road for cars. People have to pull off to the sides. That's all pleaded in the affidavits, and I don't think anyone disputes that. The road may be safe for cars, but it's not, and we have, for instance, the Whittier affidavit says that his mailbox is across the street. He's had many near misses just trying to go get his mail from automotives. The fact that people haven't, I don't think that's, as we say in our brief, the likelihood of grievous bodily harm isn't the sine qua non for standing. It has to be somewhat lower than that. And here we think that they have sufficiently pleaded that is true.
If that's true, wouldn't that mean anytime there's any increase in traffic on any road, it's going to become more dangerous?
Certainly as to an increase, and we see this in some of the other cases that the defendants cite. They've cited some land court cases where there's a de minimis increase, a 4% increase in one of the cases. No evidence put in either way in one of the other cases they cite. Here, everyone agrees it's a 30.6% increase. And even the town's own expert, their peer review expert, says to anyone living on that road, that would be a significant increase in traffic. So there's no dispute that this here is significant, and I think that's coupled with the fact that we have the individuals who have pleaded in their sworn affidavits that they have experienced significant problems and dangers in just doing their daily activities on the road. The fact they haven't been injured or killed yet can't hardly be the basis for the fact that they don't have standing now.
Thank you. Any further questions?
Thank you, Your Honor.
Thank you, Your Honors. May it please the Court. Edward Cooley of Giarusso, Norton, Cooley, and McGlone, representing the appellee defendant, Aura, Inc. I'll pick up where my brother left off. A 30.6% increase, which they like to refer to repeatedly as sort of the threshold for obviousness. In other words, at 30.6, there must be a significant increase. But a percentage increase of an already small number is a small number, even if you add to it. As the peer reviewer said, this is a town's peer reviewer, said this road historically was designed to handle much greater traffic than this and can handle it. So to say 30.6 has independent meaning is wrong, particularly in light of the traffic studies. We were charged in this case. I mean, this case comes down to two questions of fact and one determination of law. The questions of fact are, did the court, in its findings, properly find that Aura had rebutted the presumption of standing based on traffic and safety? The second question of fact is whether, having achieved that rebuttal, did the plaintiffs come forward with the kind of qualitative, credible evidence necessary to prove standing? The appeals court, strike that, sorry about that. The land court's findings of fact in that regard must be sustained unless they are clearly erroneous. And in this case, there's no construction of the facts that can render them clearly erroneous. I'll deal with them in sequence. First is whether Aura came forward with sufficient evidence to rebut the presumption of standing for traffic and safety. The record virtually overflows with that evidence. And first, let me suggest this. Traffic and safety are really two sides of the same coin, because there's no safety allegation made that doesn't arise out of traffic. In other words, all of the plaintiff's allegations regarding unsafe conditions that they allege spring from traffic. So traffic and safety are very closely aligned, as the court noted, and as I said, they're really two sides of the same coin. So what was the evidence that Aura submitted? Aura submitted significant, compelling expert testimony. It submitted a traffic impact study, a supplemental traffic memorandum, a site distance evaluation, a driveway analysis, and 2 affidavits of its expert engineer. In generating these analyses, Aura didn't just pick random numbers. It went out and collected its own data. It made traffic counts. It saw what was happening on the ground. It recorded actual traffic at the site as it was occurring.
What do you say to the argument that the traffic assessment, even if it's correct, doesn't speak to the issue of the safety of non-vehicular users?
Well, that's just wrong. So these are established, recognized traffic impact analyses. Notably, the plaintiffs haven't come forward with any alternative impact analysis that should have been undertaken. They don't come forward and say, there's this type of recognized expert analysis that's frequently used, because there isn't one. They don't have one.
But are they required to do that if you're in the position, your client's in the position of rebutting?
Only to, well, once I put in that evidence, they need to rebut what we've put in. As to our evidence, level of service is more than just, as the plaintiffs like to characterize it, it's more than just how long you wait at an intersection. Level of service is a qualitative measure that describes operational conditions in a traffic stream and their perception by motorists. It provides an index of the quality of traffic flow in terms of factors such as speed, travel time, maneuverability, and safety. What it's telling you is, what the impact study tells you is whether that road, given the amount of traffic, can be safely navigated. That naturally includes all manner of things that you could encounter. Other cars, trees, entering the roadway, all of those things factor into level of service. It's not done in a vacuum, it's done with safety in mind. In fact, LOS talks about how much time you have to wait at an intersection before you can safely enter the stream of traffic. How much time does it take before you can safely take a left turn to enter the driveways that we're talking about? So the idea that somehow the traffic analyses that were performed don't address safety misses the mark. They do, and there's no traffic expert that you've heard from that says, that opines that the traffic reports that were provided by ORA in this case were insufficient, done wrong, inappropriate to their task. In fact, if you look at Scully and the Scully affidavit that the plaintiffs submitted in support of their position that there were harms, the land court, I think rightly so, basically found that the Scully affidavit wasn't really worth the paper it's printed on. It found that it was long on speculation and conjecture and short on evidence and facts, and that's true. Mr. Scully is a traffic engineer, yet he didn't perform any traffic analysis of his own. He collected no data. He didn't provide any impact analysis to tell you or anyone else why it is that the level of traffic that the project is going to generate is somehow going to have an adverse material effect on the neighboring properties. That's also a significant point in terms of what the plaintiffs put forward in their affidavits. The plaintiffs talk about, it's all anecdotal, and they talk about, for example, I have difficulty backing my trailer out of my driveway, but that's an existing circumstance. The analysis isn't whether the existing circumstance on the road presents some difficulties. The analysis is whether the traffic added by this project will materially and adversely impact the existing circumstance.
Isn't it a logical inference that if it has difficulty backing out now when there's only X amount of cars, that if it's an increase by 30%, it's going to make it more difficult?
Exactly, because the traffic impact studies say that's not the case. The traffic increase is not significant enough. And again, and Your Honor, with all due respect, that's falling into the trap of assuming that a percentage increase standing alone is significant. It isn't. If you're starting with a small number, which we are, and that's what the traffic studies tell you, even a large percentage is still a small number. For example, 50% of 2 is only 1. So you're still talking about small numbers. That's why the peer reviewer said, look, this road historically has been designed to handle at least this much traffic, if not more. And so that's the reason when they say, well, look, everybody from time to time has difficulty backing out of their driveways, right? I mean, that's a common experience. The question is, to what degree is that going to be exacerbated by the proposed project? And here, they put forward no evidence other than that speculation and that conjecture regarding a material increase in difficulty. Now, To that point, on page 41 of my brief, I cite a series of cases that stand for the proposition that homeowners are not equipped to render expert opinions on traffic. That traffic impact is a subject of expert testimony, that you need an expert to do a traffic impact analysis and to present it. And I would direct your attention to the Baldwin case, which is in the addendum that I filed with this court. In Baldwin, the court addresses that very issue, where a homeowner says, well, that traffic analysis is just wrong, and I think that this new development is going to create problems for me. And the court squarely says that's just not enough. You haven't got the qualifications to tell us, homeowner, what level of traffic or strike that, what the impact of the increased level of traffic is going to be. You're not equipped for that. You need traffic analyses by experts. So the cases on page 41, I cite 3 or 4 of them, stand pretty solidly for that proposition. Mr. Scully did no impact analysis of his own. And now, this is important in terms of responding to the fact that ORA had rebutted the presumption of standing. They certainly had an opportunity in their oppositions to present evidence that rebutted what we had said, what ORA's experts had produced. And ORA's experts had produced evidence that said this is going to be a de minimis, almost imperceptible traffic impact. I submit to you, you can infer from the fact that Mr. Scully did not perform a traffic impact analysis in light of ORA's evidence, that had he done so, it would not have supported them. The only reason the plaintiffs didn't do a traffic impact analysis is because they knew it was going to come out badly for them. It was going to come out just the way that ORA's came out and the peer reviewer justified and authorized and endorsed. It was not going to support their claim. That's why the plaintiffs don't have one. And I submit that that's a fair inference.
Could I ask a favor, just to bookmark it, if you're in the middle of your argument? I don't mean to interrupt you, but I would like to get to the issue of the diminution of land value argument when the time is right.
Diminution, first of all, my brother relies on Epstein, which is a 2014 appeals court case. I'm sorry, 2010, I believe, appeals court case. Yeah, there it is. And in that decision, they found, under similar circumstances, that the purpose clause provided sufficient reference to conservation of land values, and that it was therefore a protected interest. They also said, however, it's tethered as well, because that bylaw talked about the right to have air and light. But it doesn't go into any great analysis. The problem with Epstein is that since Epstein, the Supreme Judicial Court has spoken at least twice on this issue. In both Kenner, decided after Epstein in 2011, Kenner is at 459 Mass 115, and then more recently in Murchison versus Sherburne, 485 Mass 200, that's a 2020 case. Murchison is, as I wrote in my brief, an undiluted statement that it is well established that diminution in value itself is not an interest protected under the zoning bylaws. Zoning legislation is not designed for the preservation of economic value of property, except insofar as that end is served by making the community a safe and healthy place in which to live. And Murchison cites Kenner for that proposition.
But, and I'm not remembering the answer to this question, but are they addressing the particular bylaws that you are speaking to?
Oh, no, they're talking about zoning legislation generally.
Is it not the case that a town could establish bylaws that provide more protections?
They could. So actually, Murchison says if you're going, diminution of value must be tethered to another recognized interest. Murchison stands for the proposition that it has to be, it doesn't stand alone. You have to tether it to some other recognized interest. So, for example, if the claim was traffic, the amount of traffic on this road is going to be so great that it's going to diminish the value of my property. So traffic is a protected interest. And as a result of that protected interest, you're going to have a diminution in value. That would be tethering that Murchison would say is acceptable. You can do that. I would point your attention, by the way, to POBITA, which I supplied in my Rule 16 letter, which also cites to Kenner and significantly sets forth a position that the purpose clause is not a sufficient source of protected interest. In other words, a purpose clause sets forth the general purposes for which other provisions of the bylaw should be directed, but it is not itself a source of the discretion to do that. That's what POBITA stands for. And POBITA, very interestingly, if you read footnote 4, makes the point that in Kenner, which POBITA cites and which Murchison cites, in Kenner, the bylaw in Kenner, which was the bylaw of Chatham, included a provision that stated that preservation of land and buildings was among its purposes. And in Kenner, the plaintiffs directed the SJC's attention to the fact that the purpose clause in Chatham had that provision very much like the clause here does. And yet Kenner came down in no uncertain terms and stated, diminution in the value of real estate is a sufficient basis for standing only where it's derivative of or related to cognizable interest protected by the applicable zoning scheme. So it goes on to say that, and Kenner's an important decision, zoning legislation is not designed for the preservation of economic value of property. It then says, to untether claimed diminution in real estate values from an interest the zoning scheme seeks to protect would permit any abutter who claims that any change in property use would diminish the value of property to obtain standing to challenge. Conferring standing in such circumstances would permit any plaintiff to make an end run around the rigorous standing requirements we've consistently recognized. So POBITA cites back to Kenner and says Kenner rejected standing, and in Kenner it was based on a purpose clause, and they brought that to the attention of the SJC. So the SJC was not blind to that fact and still found in that case that you have to have it tethered to an interest. Once this court found that traffic and safety were not a sufficient basis, as a matter of fact, the plaintiffs have not provided sufficient evidence to support those bases, they had nothing to tether to. So there was no basis to tether a diminution claim. Are there any other questions?
Thank you, counsel. Thanks. The next case is Department of Children and Families versus Father. Before we begin, I just want to remind the parties that this is an impounded matter, so we should refrain from mentioning the actual party names and instead speak to designation. Thank you.
Thank you. If I could have 15, I'll be using the entirety of the 15 minutes for. Really? Yes, thank you. Thank you so much. Good morning, members of the panel, and may it please the court. My name is Laura Openshaw, and I represent the appellant father who is here today. In determining that the father was currently unfit and terminating his parental rights, the trial court made and relied on findings in several areas of concern. However, when each set of findings is considered in the context of the entire body of evidence admitted at trial, we see that, in fact, at trial, DCF failed to establish unfitness by clear and convincing evidence, and so the termination decrees as to these two subject children should be vacated. I'll discuss each of these topics of concern in turn, and they are first, the father's understanding of the children's mental health needs, and related to that, his ability to articulate what he learned from his services and programs. Second, the father's ability to protect the children from their mother. And third, the concerns about domestic violence between the parents. First, as to the father's understanding of the children's needs. To start, it's important to understand that 6 months before the trial, DCF cut the father's visits with the children down to just one visit per month. And there was no evidence that the father was ever authorized to engage in family therapy with the children or to speak with the children's clinicians. where the father's access to the children and to clinical information about them was as limited as it was, it is fundamentally unfair for the court to expect the father to have a nuanced understanding of the children's needs. He never had a chance to learn. Given the access and the opportunities that he did have, he demonstrated an understanding at trial and through his behavior that the children would require patience and an individualized approach that was responsive to their needs. He did express this at trial, for example, at transcript 101, 268, and 269. And in fact, DCF's own records demonstrate that during the father's visits, limited as they were in the 6 months prior to trial, but also before that, he was able to treat the children equally. He was able to respond to their needs, and most importantly, he was able to model empathy. To the extent that his understanding of their mental health needs was not as comprehensive or nuanced as it could have been, it was not so deficient as to constitute a grievous shortcoming that put the children's well-being much at hazard. And he demonstrated that he was willing and able to engage in a variety of services that would have allowed him to continue to learn. Related to this was the court's concern that the father didn't learn from his programs and services because he couldn't clearly state at trial what he had learned. It's uncontested that the father completed a great number of services. He completed a nurturing parents group, he completed a trauma and resiliency group, he completed an anger management group, he was in therapy for more than 2 years. He participated in a psych eval, and he signed releases to DCF to verify his engagement in all of those services.
Acknowledging the efforts that the father went to complete those services, was the question before the judge also whether there was a demonstrated benefit from the services, and if so, where was that?
That was the question that the judge was to consider given the evidence that he had completed those services. But there were a couple of issues that the trial court should have but didn't consider in answering that question. One was the fact that the father's behavior had observably changed, both in regards to the conduct during visits, where there were some concerns about, for example, promises or things said in the visits that came up earlier in the case, and that the current social worker at the time of trial said really wasn't an issue anymore. As to domestic violence, which we'll speak about in greater detail in a bit, there was the uncontroverted evidence that starting in early 2021, there was much less of looking at the law enforcement records as well as the father's criminal record. There was a degree of diminution of aggressive or violent behavior, particularly in comparison to the evidence before that point. And there was what he was able to express at trial, given that the father is not a first or even a second, English is not his first or even his second language. And throughout the record, there were examples of the father doing his best to communicate in English about matters that were less nuanced and less complicated, and sometimes having difficulty. And the trial court at times, particularly with regard to the black sheep idiom, but I think also more broadly, took his use of English as it was and took from that he just doesn't understand. Whereas first there was the evidence of behavioral change, as well as the fact that he was doing the best he could to explain what he had learned.
So based on what you just said, are there any specific findings that you find were clearly erroneous, or is it more a balancing?
The finding, there were a number of findings that were clearly erroneous. I think the one that, going to what was for the judge central issue of domestic violence, was the issue that the judge found that at the time of trial, with trial concluding in January 2023, that the parties' relationship was, in the trial court's words, currently permeated with domestic violence. That was clearly erroneous. The evidence before 2021 was what it was. I'm not here to minimize it. But following December 18th, 2020, there was a period of 2 years going up the trial where you don't see a number of things. You look at the law enforcement records and you don't see police responses, you don't see 911 calls, you don't see bystander calls, you don't see arrests, as well as the father's criminal record, where you don't see restraining orders, you don't see new arraignments, you certainly don't see convictions. And that was a period of significant change. And it happened to align with the period of time where the father had stepped up his engagement in all these services, including the anger management.
I'm missing counsel, and I know the father made efforts, and I know times got better, so to speak. But that doesn't change the fact that a relationship can still be permeated with domestic violence, even if it stops at some point. If there was a lot of episodes beforehand, why is that an erroneous finding?
That's erroneous because it doesn't address the very purpose of these services, which is behavioral change. Then the way that DCF and the court was to know that there was behavioral change is by seeing a change in behavior. I do want to address the voicemail. Certainly that was significant to the court, and I imagine significant here. And we're not, at trial, the father acknowledged that it was an ugly call. He apologized for it. We're not here to minimize the call. Viewed in context, that was virtually the only evidence of any sort of aggression in 2 years. And where the father had been engaged in services, continued to be engaged in therapy, and his response to being asked questions about that call, showing contrition, showing an acknowledgement that it was wrong, is itself evidence that he was on a positive trajectory. He was in the process of becoming a different person and addressing concerns that the court had had. That was in 2022. That was in April of 2022.
So I just want to make sure I have a chronology right. In 2019, he committed an assault and battery on the mother. In 2020, he threatened to run the mother over. And then in 2022, he made that recording. Based on those 3 incidents alone, and there are others, but based on those 3 incidents alone, why is it wrong for a judge to make a finding that domestic violence permeated this relationship?
The judge was wrong because in view of the last 2 years before the trial, there was really the only evidence was the one call, was the one incident. Again, it was something that the trial court had the discretion to give some amount of weight to, but the whole purpose of engaging in all of these services is to take a look at oneself, to determine how one got to the place one has gotten in life, and to move on from that. And there are a number of ways the father could and did show that he gained a benefit from the service. He didn't make would it have been better if he had made a complete 180 in terms of the way that he thought about this relationship, and that call had not happened, of course. But as in other areas of behavioral change, sometimes change comes more gradually. Sometimes it's in matters of degree. And in this case, both the court wasn't required to, in order to find that the department had not met its burden, the department didn't need to see that there were 0 incidences. It was only necessary for the father to show that he had made behavioral change such that he would not put the children's well-being much at hazard. And he did the work in this case over a period of some time and in several different ways. And particularly in this case where he did not have an intention to co-parent with the mother, and he testified that, and the judge credited this, where he demonstrated that he had an evolving understanding of what had happened that had led to the removal, that his current social worker took him at his word and testified to that as well, where prior to the removal, he had shown that he was willing to make difficult calls to DCF, to the authorities when needed to protect his children, which he did. He also had testified about having gone to the probate and family court to seek custody after after DCF didn't intervene. The judge didn't make findings about that, but the testimony was there. That he had demonstrated that he was somebody who had made changes, who had benefited from the services that he had done, and who demonstrated he would continue to engage in whatever services he would need to continue to engage in. I think it's also important in this case where, to briefly address the issue of the father's substance use. The only substance use of which there was any evidence in the record in the period of time during which this case was pending was the father's occasional and legal use of cannabis. The DCF social worker had acknowledged that there was no evidence that the father had ever parented the children under the influence. This is certainly not a case where there was a clear nexus between the father's substance use and harm to the children, and I submit there was no nexus here at all. In fact, in this case, where the father worked nights and was already involved in many services, it was unreasonable and unfair for the court to fault him for not also doing a substance use evaluation. The evidence of engagement in services, together with the evidence of behavioral change, was enough for the father to demonstrate that the father was not currently unfit at the time of the trial and that any unfitness was not likely to continue into the future. We're asking this court to vacate both termination decrees and to remand for further proceedings. And as to the remaining issues, I rest on my brief.
Thank you.
Good morning, Your Honors. May it please this court, I am Attorney Saranya Suresh, representing the Department of Children and Families in this case. I am here asking today that this court affirm the decree of termination of parental rights that was entered by the trial court. The decision reached by the trial court in this case was supported by the evidence. The trial judge reviewed the evidence in great detail and entered in 341 uncontested findings of fact. The trial court determined that despite some participation in services, father continued to engage in controlling behavior towards mother, failed to gain any insight into his role in perpetuating violence, and lacked any understanding of the traumatic impact that his behavior had on his children. Father argues first that the evidence before the trial court is insufficient, that any unfitness was only temporary because he had made significant progress in addressing his shortcomings. This is not borne out by the extensive record. The department would submit that the first of the trial court's conclusions of law refer in detail to the parents' inability to improve upon their parental deficiencies. I would refer this court to conclusions of law 62, which speaks to father's history of domestic violence and his minimization of that. I would speak to conclusion of law 67, where father maintained an adversarial stance historically throughout the care and protection case and refused to engage in the tasks on his action plan, arguing that he was relying on mother to be the unifying parent. I would refer the panel to conclusion of law number 73, where father denied that the children had suffered any trauma whatsoever while they were in the care of their parents. This goes on to demonstrate that the father had a complete lack of insight into the enormous trauma that his children had had, both due to the domestic violence between the parents, the substance use particularly of mother, as well as the physical violence that was committed upon the older child. Despite having been given every opportunity to change his behavior, father was unable to demonstrate any behavioral change. The court found that despite father's compliance in services, beginning about in late 2020, which was a year after the children were removed, the court found that father did not meaningfully benefit from these services. I would remind the court this is not the first care and protection case involving this family. This is actually the third care and protection petition, and it is the second time that the older child was removed from the parent's custody. Additionally, father argues, if I could just back up for a second, I also want to refer the court to the trial court's findings from 39 through 64, where the trial court actually devoted an entire section of its findings to the relationship between the parents and the domestic violence that had, contrary to counsel's arguments, in fact permeated the parents' relationship from the beginning right up to May 2022 and later, as evidenced by the voicemail. Father argues that the trial court was clearly erroneous in finding that the relationship was permeated with domestic violence. Father argues there's little evidence of domestic violence given that there was no arrests and no criminal charges. However, as this panel is well aware, there is no need for an arrest to occur for domestic violence to exist. In April of 2019, there was an incident between the parents where father assaulted mother. Mother at the time took out a restraining order detailing a 6-year history of domestic violence. At trial, mother walked that back, which the court did not find credible. The trial court found that mother's affidavit to be credible, detailing the physical assault and emotional abuse that she had suffered at the hands of father. I also want to take a moment to speak to the domestic violence that occurred subsequent to the removal of the children most recently. The court did find in finding number 53 that father continued to engage in threatening and controlling behavior towards mother through the case of this care and protection. This was evidenced by father's unwanted presence at mother's home, including during at least one, if not two, parent-child visits. It was evidenced by father's theft of mother's belongings, including a scram machine that she was dependent on for her probation compliance. It was evidenced by father threatening to take the children from mother's care and to report mother to the department. At trial, the transcript will indicate, and the court's findings also speak to this, that both parents continued to deny and minimize domestic violence. As part of the current action plan, father was required to engage in an intimate partners or domestic violence abuse program. Father denied to do so, claiming that he had done such a program 2 years prior, I believe it was in 2017, and that he no longer felt that he needed to engage in a program. Father did engage in an anger management program during the pendency of the current proceedings. However, the court found that father had not demonstrated any of the behavioral change needed, based not entirely but largely on the voicemail that was entered into evidence from May of 2022. I also want to take a second to bring the court's attention to the voicemail itself, in which mother stated, and the court so credited, that, and I quote mother's statement here, "You have beaten me enough number of times." And the court found that based on each of the pieces of evidence individually, as well as all of the evidence taken in totality, that domestic violence did indeed permeate the parents' relationship, essentially since the beginning of their relationship. Your Honor, the trial court did find that the domestic violence by itself would have been sufficient to terminate father's parental rights. But that was not the only parental deficiency that plagued this father. Father has never had custody of any of his 8 children. He has never parented any of his 8 children. Father's own testimony indicated that he was not involved in the prior 2 care and protection cases involving his family, that he had relied on mother as being the reunifying parent. For the first 2 years of this petition, father declined to allow the department to visit his home, again stating that he was not seeking to be the reunifying parent. Father does argue, and the court did find, that father had engaged in a limited number of programs. However, as this panel is aware, as adoption of law now and other cases tell us, merely engaging in services is not sufficient to indicate behavioral changes. A parent would be unable to protect their child from continued abuse if they're unable to acknowledge the chaos caused to their child by being raised in a chaotic and damaging environment. I do want to refer the court to findings of fact 247, where the father continued at the time of trial to lack insight into the older child's disclosures of physical abuse by her mother. Findings of fact 224, it's also in the transcript at page 97, where father took no responsibility for his role in the removal, stating, "I did not contribute to the removal. I would never lose them." Father did do a trauma and resiliency program. However, when questioned about what he had learned about that program, father could only say, "I would reassure them and do activities with them." Finding of fact 248, the trial court found that father was unable to discuss with the social worker any techniques that he had learned on parenting a child with trauma. I will remind the court that the expert on this case opined that the older child was diagnosed with PTSD, so it would be important for father to understand the trauma that she had been through. When questioned at trial about what services he would put on an action plan should he create one himself, father responded, "I don't know." Again, indicating a stunning lack of insight into his own parental deficiencies, as well as the trauma and the needs of his children. This is in the transcript on page 295 and 296. The trial court found that father gained no benefit from the trauma and resiliency program, as well as no benefit from the anger management program, given the credible evidence to the contrary, which included the voicemail admitted at trial. Father did complete a STAR parenting course, but again, finding of fact 274, he was unable to understand why it wasn't on his action plan and testified he did it because DCF asked him to. The court found that he gained no benefit from this as well. The court found that the department was unable to verify what father had learned at therapy, again, because father had failed to make his action plan a part of his therapy treatment. And father declined to permit the department to have candid conversations with his therapist. When questioned at testimony as to why he was in therapy, again, father's response was, because the department wants me to. Your Honors, father argues that the trial court drew an adverse inference against him because English is not his second language. It is important to note that father never raised this issue at trial. In fact, father was specifically asked on cross whether he had ever requested an interpreter through the court, and he responded, no, why? Finding of fact number 19, the trial judge found that despite father's claims, the trial judge did not find credible father's claims that he did not learn English until the age of 19, and found that he did not present any difficulty in understanding English. Counsel did argue that father mispronounced some words or perhaps misunderstood some words, but as you will see, the evidence at trial indicated that the trial court understood those words and interpreted them within the specific circumstance within which they were used. I want to take a second to address the black sheep comment that I know has come up. The ongoing social worker testified at trial, and the court credited her testimony that one of the first things that she did upon meeting with father the very first time was to explain the meaning of the black sheep comment. Father sort of indicated that he understood that and continued to refer to this child as the black sheep. Again, the court found this to be concerning given that this was the child that came into care with bruises and injuries on her body. I want to take a moment to pivot to the issue of visitation. I know that there was a question of parent-child visitation as well as visitation with the half-brother. At the outset, the department would submit these issues are waived because they were never raised at trial. Under Chapter 119, Section 29, the subject children of this CNP as well as the sibling with whom visitation is sought retain the right to go to the juvenile court to file a motion requesting visits, and that would in fact be the appropriate forum. This court should not remand the proceedings back to address the issue of visitation because the appropriate forum would be the juvenile court, the trial court that continues to maintain jurisdiction over that. If the panel has no further questions, I would rest on my brief.
Thank you.
Thank you so much.
Good afternoon, Your Honor. Jacob Lavin for the appellee children. We hold the same position as the department that this court should not disturb the trial court's findings, that they are thorough, that the judge gave due consideration to all the facts, and that any decision that the trial judge made with respect to the termination of father's rights and freeing these children for adoption is sufficiently supported by the record.
Counsel, can I ask about
Yes,
the visitation issue between the children?
Yes, Your Honor.
What evidence is necessary for a judge to make that type of order in and of itself? Is it the fact that they're siblings alone? Is that enough?
I don't think so, Your Honor. I think I would refer the court to the recent decision in Flavia. So if unlike here, if as in Flavia, the children were separated by the state action that's before the judge, that judge should take into consideration what's happening. Is one of those separated siblings going to a residential program and the other of those separated siblings going either back to the parents or to an adoptive resource? That's something the government did. It caused it. It should be taking that into consideration. And more importantly, the juvenile court judge has jurisdiction over all three of those children. in a case like this, you want to know, if you're the trial judge, that consideration's being given by the department to contact with siblings that the children grew up with or had contact with on the regular growing up, but you don't necessarily have jurisdiction over those children. In this particular case, 3 of those children are in a guardianship with maternal grandmother on one side, and the one remaining half-sibling is in guardianship that happened in another court long ago. So the judge sitting at the trial in this case has to take into consideration that there are siblings, but that particular judge is actually limited in what they can do. So regarding that visitation. Here in this case, there were visits. So this judge wasn't primarily focused on that because it was happening, more likely than not. In my remaining 34 seconds, unless anyone has a question, I will rest on my brief.
Thank you.
Thank you.
Thank you. And the final case the panel will hear is labeled Child versus Mother, 23P 1350. Again, this is an impounded matter. I'll remind the parties to not mention the actual names, instead to refer to the individuals involved by their designations.
Good morning. May it please the court, David Cohen on behalf of the appellant mother. This court should vacate the termination of parental rights decrees here and reverse the adjudication as to the oldest daughter. And that's because the trial court abused its discretion in repeatedly declining to decide multiple visitation motions for a period of what basically amounted to 15 months before and during the trial. The key case here is the adoption of Franklin. I'll speak about that more in a moment because I would like to go over with it, but that talks about, well, DCF could not have shown by clear and convincing evidence here during trial that, or before, that continuing to prohibit visitation was necessary to prevent harm to the children, at least 2 of the 3 of them. I'll speak about the middle child separately in a moment. And the trial court's inaction on these motions prejudiced the trial court's outcome.
So I just want to make clear, when you're talking about prohibiting visitation, are you making a distinction between personal visitation, well, yeah, in-person visitation, video visitation? I just want to be clear what we're talking about.
I'm acknowledging that DCF claims, well, DCF said we suspended visitation and then really tried to suspend visitation in total. It made that motion to the court, but then said, oh, well, we haven't changed anything. We're still, well, we did change. We stopped in-person visitation, but we are doing virtual contact. So I acknowledge that's, those are the facts of the case. I mean, effectively, they constructively terminated visitation. I realize that the Thaddeus case says there's no bright line rule about when a suspension becomes a termination, and also does say that in the case in Thaddeus of a COVID-19 pandemic, despite the strong presumption of in-person visitation, you can suspend visitation for a period of time. But DCF policy is 6 weeks. Adoption of Linus and Franklin talk about even 5 or 7 months being too long. We're talking here about 12 to 15 months. Does that answer your question? Okay, so the reasons that, the 3 reasons really that there's prejudice from the trial court's inaction. One is that meaningful parent-child visitation is an element of termination of parental rights at trial, and the trial court relied on that here. That's conclusions 35, 3, and Roman numeral 3 and 7. The other is the great length of the suspension of visits, and we just talked about that in terms of Thaddeus and all of that. And the third is really, which goes to the Franklin case. It's that Franklin is a very applicable case in most regards here in terms of the procedural history and the facts. It's very similar. You've got a unilateral DCF decision on the eve of trial to halt visits, suspend, terminate them. DCF moves for the trial court's ratification of that suspension. prompt motion from a parent, in this case a child joining it, for a motion to increase visits. The trial court saying, basically tabling the motion until the end of trial, which lasts 6 months, effectively making it moot. And no hearing, really, except the trial itself here, on whether there was clear and convincing evidence that having visitation resume would be harmful to the children. Now, we know the circumstances here, but so Franklin is really about, I mean, Franklin affirmed a termination of parental rights decree, but it said, well, that's because there's overwhelming evidence of unfitness. And here, for a lot of reasons, there is not overwhelming evidence of unfitness. For one, I would point to the competing experts at trial, where you had DCF experts and experts for the mother, the DCF expert said basically whether mother had serious untreated mental health problems. There's clearly a dispute of fact here, and you had the expert testimony. I realize, the trial court gets to credit one or another, but overwhelming would not be the proper way to describe this. Mother's expert, her therapist, talked about there was no evidence basically that the trial court clinician who had testified for DCF was wrong about mother having serious mental health delusions, paranoia, all these kinds of things. And also about the Department of Mental Health, the trial court clinician said mother needs Department of Mental Health services for all these paranoia, delusions types of things. And the mother's expert disputed that. I would also note, though, by the time of trial, mother was pursuing that application. There were delays, but mother was pursuing that application with DCF to get it to pursue Department of Mental Health's referral. So she did that anyway. I would also say, the consistent presence in the children's lives. This is a mother who took care of these children for many years. And they knew her, and they knew her well. And that differs from the kind of overwhelming evidence that Franklin talked about. There you had an unfit father who had been incarcerated for 3 years, charged with intent to murder somebody with a sword, drug dealing in front of the children. We don't have those types of things here. What we have is mental health, which I'll try to get to as well some more in the next few minutes. The claim that there's no prejudice because the visitation motions were simply a restatement of a no reasonable efforts motion, a Rashida motion that was decided 5 months earlier, is not persuasive, and that's for two main reasons. One is there are different standards of law that have to be applied for those motions. A no reasonable efforts motion is by a preponderance of the evidence, DCF has to prove that it made reasonable efforts. But the standard here, as we've just talked about, is there has to be harm to the children to have continuing visits, and it has to be proven by clear and convincing evidence that there's going to be that harm. They're different legal standards. There's also the circumstances.
But the reason for limiting the visits had to do with the sort of the safety of the DCF workers.
Yes, but that was never tested. This gets to the circumstances had changed. I mean, there had been, that was heard in October and early November and decided on the papers. In January of 2022, that's when this incident happened around the gender exploration of, that was really what prompted it. And it was the oldest daughter calling the middle child by the middle child's male given legal name that really prompted the escalation there. I acknowledge there were some problems in visits, throughout the course of this case, even though mother visited consistently. But visitation was not tested. I mean, here are some examples. In March 2022, just a month before trial, the older child, the daughter represented by my colleague here, unfortunately was hospitalized, was at the Little Heroes home. Visitation could have happened there. It was open, would have been supervised by the staff there. DCF did nothing about it. The court did nothing about it. There was a motion on the table. I don't even know that mother knew that she could visit, but there is record evidence that she could have.
How within the trial findings did the lack of visitation prejudice your client?
I think I just mentioned for those three reasons, Your Honor, that the great length of the delay, the lack of overwhelming evidence of unfitness, And maybe if mental health is something you're concerned about, the lack of overwhelming evidence on fitness, I mean, that goes to, as well, the trial court's finding that it did not expressly find or have evidence, I'm looking for the exact quote, that, that mother caused the injuries to the oldest daughter.
But the inference was a failure to protect.
That was, Your Honor, and that's adoption of Yelena. And if I may just talk about that for a moment, because appellees mentioned that. That's right, a failure to protect. Yelena is primarily about domestic violence between two intimate partners, and that basically the trial court doesn't have to determine whether it was one or the other. It had to be one or the other, and essentially makes the finding that...
Here it's not even that complicated, because there's not even another adult to sort of, where someone has to choose who's doing this. Right?
Yes, but then why didn't the trial court made a decision? I don't have enough evidence to show that mother caused the injuries. So how can that stand with the trial court's determinations here? I would also say on mother's action plan, DCF said you must acknowledge the substantial physical injury to the child. This was a task. She has to do this, otherwise she doesn't get to reunify with the children. You have to acknowledge that you were the children's abuser. And this is the kind of thing that the Yelena case specifically calls out. At 550, at page 550, DCF should reconsider the usefulness of including a task on an action plan for mother to acknowledge responsibility of abusing the child. It's the catch-22 nature of it. If mother doesn't know, I recognize mother offered explanations here that the trial court did discredit, but if mother doesn't know, then she doesn't know, and how can she acknowledge it? And if she speaks, if not, then you have Fifth Amendment implications as well. So that's one of the lessons of that case. I see I'm running out of time. There's much I would like to tell you. Can I just, for a moment, finish the gender exploration issue of the middle child? Mother talked about religious objections. She talked about the child, but she talked particularly about this was a child who actually was 5 years old who started identifying as a different gender. This is mere months after being placed at a foster parent's home where one of those foster parents identified as transgender. It's not unreasonable for the mother to have connected the two and said, when I gave you this child, or when you took this child, this was not an issue. If a mother whose child was not in DCF custody made a parental decision against using particular pronouns or having the child go to dress in school, wear a dress to school, a male child, we might disagree with that decision, but we would respect it as a parent, as a parent's decision in the child's best interests. That's not what happened here. This became a big hullabaloo for a year or more and really affected visitation, and is why the court's refusing to hear those visitation motions timely was also prejudicial.
Thank you.
Good morning, members of the panel. May I please the court? My name is Jennifer Wang. I represent the appellant child. My time is short, so I won't repeat what my brother just covered regarding the fitness issue. I will jump straight to the visitation of siblings. The court wrote that sibling visitation could occur if it is consistent with the therapeutic needs of the children. The order is a little problematic for several reasons. First, it's the faulty legal standard. We know that sibling visitation should be happening under reasonable, practical, in the best interest standard under the statute, Chapter 119, Section 26B. And second, the order doesn't identify who would be the arbiter to determine the therapeutic needs of the children. And third, the order failed to specify the form, the frequency, the schedule, the time of the visitation is just overly vague. I know that the department in its brief stated that the court is under no obligation to make orders of sibling visitation because the department has organized it throughout the case and will continue to do so. However, the record indicated otherwise. From January to September 2022, within 9 months, there are only 2 visits between the siblings, according to the testimony of the department social worker. And even assuming that the sibling visitation is ongoing, it is happening, the concern is that we know that the 2 younger children are in pre-adopted home. In the event they become adopted, then the conflicted legal status of the children, 2 groups, will become, they will be put at jeopardy of losing sibling contact because the foster parents, or the adoptive parents rather, once DCF is out of their lives, they will not be so obligated without a specific court order.
Can the children seek that independently?
In uncertain avenue, perhaps, but they're young, so, and also it's a very burdensome act for the children to shoulder that burden.
So you're saying this is a particular circumstance where the judge was required to set out at least a minimum schedule?
Absolutely, yes, Your Honor. And also, I cited adoption of Flavia in my brief. There's another case as well. It's adoption of Ido. There are 12 children, 12 siblings in that case. And I believe Justice Singh was on the panel for that case. The trial judge in that case declined to order sibling visitation, stating that it's not reasonable, it's not practical to order sibling visitation considering so many children, and left it to the discretion of foster parents and DCF to collaborate with each other. This court, the appeals court, disagreed and stated, yes, we acknowledge it is a formidable task to ensure visitation among siblings in such complicated circumstances. However, it is precisely in a complicated circumstance when the children are at the most risk of losing sibling contact. So the court reversed the order and remanded. I also want to touch on briefly, I see I'm out of time. I'll just conclude by quoting Chief Justice Green said, a systemic problem requires systemic solution. On behalf of my client, a child from the racial minority family who has been going through a lot, I thank you for your time, and if there are no other questions, I'll thank you.
Thank you.
May it please the Court, Jeremy Bayless for the Department of Children and Families. This is a case involving a mentally ill mother who had exposed her children to a variety of different sorts of harm and was involved in care and protection proceedings going back to 2012 in New York when the oldest child was failing to thrive because mother claimed she wasn't eating because there was a demon in her. Mother fled New York to Massachusetts, which is how she came here and we became involved. During Mother's interactions with the department, she has been threatening, aggressive, and confrontational. During her interactions with her children at visits, Mother has been aggressive, threatening, and confrontational. My brother brought up the position that Mother had religious objections to the gender exploration of the middle child. And the court acknowledged those in several findings and its conclusions, that those were valid, that mother has her beliefs, and there they are. The problem with mother's behavior was not that she had a religious objection to the middle child's gender identity or exploration of that. It's that mother's reaction to having that problem was not to calmly address it, to seek to process it, and one of the findings, I apologize for not remembering the number, to reassess her approach. It was to aggressively yank the hair ties out of his hair, to shove staff, to assault people in the children's presence because she was angry, because mother's reaction to when things did not go the way that she wanted them to was to be aggressive and ultimately to be violent in the presence of the children. The middle child said during that meeting he was less than 7, "Mommy, you're mean," and then after the meeting was standing as if catatonic, holding a toy. The children were harmed by mother's behavior, and the visits were, in-person visits were moved to virtual. Visitation was not ceased because department staff were not safe around mother when she became angry, because the children were not safe around mother when she became angry. That was properly considered by the court. It was properly considered by the department, and Thaddeus does permit virtual visitation, even if it is disfavored, because the circumstances in this case made it such that in-person visitation was harmful to the children.
Be that as it may, wasn't the court obligated to deal with the issues as they arose instead of making everything everything became a foregone conclusion by sort of stopping that kind of contact?
It was, to put it lightly, it was unfortunate the way the visitation motions panned out. Now, there was in September a motion, an abuse of discretion motion regarding visitation. The standard for that is that the parent has to prove that the department abused its discretion. Then there was the Rashida motion filed in October. The standard for that, significantly more favorable to the moving parent. The department has to prove by the preponderance of the evidence that it is making reasonable efforts. And part of that motion was directly addressing the visitation argument raised in the first motion. So by a lower standard of proof, higher standard of proof, I apologize, the department, by a higher standard of proof, met the burden. There was a ruling on that motion, a ruling that could have been taken to a single justice of this court if mother were inclined to so pursue it, giving them an avenue to address the visitation order, even if the court had not, was not moving in as timely as would be preferable. Also important to consider with the visitation order is I do not believe the juvenile court expected it to take quite so long for that visitation order to be heard with the trial. Trial was supposed to start in January, and trial did not start in January because mother asked for a continuance. She can't cause a delay and then claim to be prejudiced by the delay that she caused. Furthermore, in light of all evidence of mother's behavior at visits, even if we were to take the visits that were tainted by mother's attitude towards the middle child's gender identity and focus on the other visits, they still demonstrate that mother was not behaving appropriately at visitation and that it was causing harm to the child. The middle child refused to go to visits for a while. When he did attend, mother berated him for not going to visits to the point where he fled the room and defecated in his pants in fear. She routinely blamed the oldest child to the child's face for anything that the middle child did wrong at the visits. The gender identity issues were blamed on the oldest child. The middle child not wanting to attend visits, blamed on the oldest child. Mother's behavior through visits, even putting aside her outrageous reaction to her disagreeing with the gender identity piece, would have supported not stopping visitation. That was a separate motion that was filed and was denied, but transitioning visits into a virtual setting until there was an indication that she could do better, an indication that never came. My brother contends that there was not overwhelming evidence of mother's unfitness. That is not accurate. The existence of testimony to the contrary does not, especially when that testimony is not credited by the court, doesn't take away any of the court's uncontested, numerous findings demonstrating that the children in mother's care were covered in bites, many of which were, the oldest child, not all the children, just the oldest child, were adult-sized. Mother gave a variety of different explanations, none of which could explain the actual injury. That's a pattern for mother, because the children were removed when the oldest child had burns on her face that mother provided a variety of different competing explanations of that also weren't credible. The oldest child said that mother bit her. The oldest child provided conflicting stories as to how she was burned by spaghetti or other implements. These children were harmed in mother's care.
Well, I want to make sure you leave enough time because I'd like to discuss the visitation issue.
Let's do that now.
Can you tell me how that order doesn't conflict with adoption of RICO?
That order is essentially leaving supervising visits to the department, which is within the court's authority. Garrett sanctions it, Flavia sanctions it. The statute, and most importantly, the statute sanctions it. The court says that visitation should occur, but acknowledges that these are children with high levels of needs that have contentious relationships with each other. It also acknowledges that visitation was happening at the time and was being facilitated by the department. And so, to the extent that visitation is occurring, 2 of the 3 children are appellees and do not want a structured order providing a minimum schedule. It was not air for the court to essentially encourage visitation without providing a hard and fast schedule for it. If you look at both the parental visitation comments and the sibling visitation comments, the juvenile court was very concerned about providing a mandated schedule of visits given how much was in flux with the relationships and with the potential damage to the children if they're forced to engage there.
Certainly understanding that setting a specific schedule might be difficult, the statute says the court shall provide visitation.
Are you talking about 25B? Mm-hmm. The court or the department shall. In this case, the department
left it in the discretion. So how does shall and discretion equate with one another? Couldn't the discretion of the department be, we don't think it's in their best interest, so we're not going to do it?
Well, anytime that there are medical concerns, mental health concerns, there needs to be a way for, if a visit is harmful, not to have it happen. And so whether or not there is visitation is not left to the discretion. It's who is deciding when it is therapeutically necessary. Someone has to be that decider. And the statute says the court or the department. And so in this case, the department is evaluating that. And the saving grace, if that is concerning, because that does leave avenues, it leaves potential circumstances that would be concerning, is the fact that, as in Flavia, the children have the ability to go back, children who are represented by counsel, as Sir's parental rights were not terminated, her counsel's not going anywhere, have the ability to go back and file a motion for sibling visitation. And to have that heard if the department is not fulfilling its obligation to provide visitation consistent with whether it's to the benefit of the children. There's no need to disturb the proceedings below and to disrupt the lives of the 2 appellee children who did not want a structured visitation order with their sibling, when this is a problem that, if it arises, has a legal means for redress. Conveniently, I see my time has elapsed. So if no further questions, I rest on the brief. Thank you.
Thank you.
May it please the court, I'm Sherry Krasner on behalf of the 2 younger children. I will refer to them here as middle child and youngest child. Very much appreciate your time today in this very long session on a July day, and the importance that this court always attaches to termination of parental right cases, having oral argument in all of these cases. And while I want this court to fully deliberate after hearing argument, I must ask that the court act with as much speed as possible because of the interests of the children. The middle child in this case came into care at 3 years and 8 months. The middle child will be turning 9 in 2 months. The youngest child was removed a few days after birth, and she will be turning 5 at the end of this calendar year. They deserve finality from this court. Just 4 bullet points to refute some of Mother's key arguments. This wasn't a case about proving or disproving that Mother caused the injuries to the oldest child. It was about whether Mother had the capacity to keep the children safe and what kind of self-awareness that she had to address her own shortcomings. It's what this court in adoption of Orrin talked about as a constellation of factors and not just one factor. This wasn't a case about whether there's an alternative argument for why the appellant child and the middle child experienced so much dysregulation when they came into care. Mother's theory was that it was the removal itself and some of the difficulties that they had in their first foster placements. And while that argument isn't implausible, the inferences that the judge drew here, that the behaviors were related to the inadequacy of Mother's care, were reasonable and were fully supported by the evidence. And really, on appellate review, that's all that matters. This isn't a case about Mother's closely held religious and cultural beliefs and Mother's inability to give any credence to the middle child's exploration, and the hostility that she showed toward the child was clear evidence of a grievous shortcoming. We know from cases like adoption of Betsy and adoption of Jock about how that profound inability to be attuned to a child's needs, or even worse, to be dismissive of those needs, is evidence of unfitness. Finally, it's not a case about whether more visitation would have made a difference in this case. There was visitation throughout this case. The suspension of visitation was very brief, and giving the middle child some agency over whether or not there should be visitation was important for that middle child's emotional well-being. It wasn't a case like an adoption of Rona where there was a precipitous decision made to suspend visitation and that influenced the outcome of the case. It wasn't a decision like some of the language in adoption of Franklin where was the department trying to leverage an advantage by suspending or manipulating visitation. This was a case where all decisions about whether there would be visitation and what kind of platform, whether virtual or in person, were made with the safety of the children as the primary consideration.
Counsel, what is your client's position regarding sibling visitation?
The children, what we know from the records is that the children enjoyed the visitation with their older sibling. We also know from the record that the pre-adoptive parents were, of the 2 younger children of my clients, were committed to continuing visitation. I didn't really address the legal argument because it wasn't my child's client's legal arguments, but I certainly would say that Chapter 119.26, capital B and then small letter b, that the judge's decision was consistent with that provision of the statute, and that there should be no remand back to the trial court, and that child can seek, by filing a petition in the trial court if she wants specific visitation. See that I have 2 seconds left, so I handle that pretty well, and I thank the court and the rest of my brief.
Thank you. Thank you, everyone. That concludes the sitting for this morning. I appreciate all the help of all the staff involved. Thank you all.
All rise, please.